police yourselves. We are supposed to, if we're going to video the thing, you've actually got to be using it for your own purposes, and besides which, it's being live streamed. So there's that. Do we have anyone who is in the meeting who is from another team or from in this competition, not with these two teams? If you do, please identify yourself at this point. Ah, good, because I would have to exclude you. The Colorado Bar Association will be doing some photography of sorts, and I think it will probably be the screenshots and things like that. So by participating in this, you consent to have your image recorded by the Bar Association so that we can show all concerned how wonderful you are in this competition. We are not going to have recess unless there's some sort of an emergency. And the word emergency is very fuzzy, and I will leave it to you to declare your own emergency. So if there's an issue that you have that you believe you need to leave and do something, looks like we're all in somewhat separate places. I think you should do that on your own, and maybe possibly a parent or a team coach or someone might monitor that and get back with us on how things are going. But we probably, unless you're at the podium or unless you're a witness, we're probably not going to recess even for that. However, I am going to have a little delay between each scoreable event, and I'm going to tell you why. The judges, these scoring panelists really want to be diligent. They want to write down important things, and they're going to be doing that as they go. So we are going to allow them to complete their scoring. So I'm going to basically give about 30 seconds to maybe a minute between each scoreable event for them to finish their work, okay? And so what I will do is I will tell you, you may now proceed. That's the magic word that tells you that you can go to the next one. A scoreable event will be something like opening statement. A scoreable event will be an examination. And then a cross-examination is another scoreable event. Do you guys understand this? If there's any confusion, let me know. Okay, because we want them to actually do their work well.
Judge,
and you don't want to be.
I'm sorry to interrupt, but
please.
Can I just double check that all the scoring panelists have your score sheets?
Good question.
Yes, thank you.
I do, but I do have a question on that.
I don't have mine.
I'm sorry, who is that? You're
Sydney, I don't have mine.
okay. I'm gonna get the link for that and I will put it in the chat.
Okay, thank you.
And
my question was on the plaintiff's trial roster for team code. It says 1, but that's not all the team codes that I have are someone's name. I see that the defense is team code Gabe. I don't know the team code for the plaintiff.
the plaintiff, so defense
It should be Stanley.
Stanley, correct.
Thank you.
Yep. Any other questions from scoring panelists on score sheets? And I will get that link and put it in the chat.
Yeah, and please confirm that you have it before we begin. There's no point in us beginning without you being able to score.
Yes.
And while if you have any no further questions, let me go ahead and continue through my little go sheet here. There we go. Any disputes arising out of this competition must be reported in accordance with the competition rules. You've all studied them, so you know. Your compliance with time requirements will be considered in scoring. Now, the timekeeper, do we have a timekeeper for each side present in the chat room? Please announce yourself.
Yes, Your Honor.
Yes, Your Honor.
Okay, perfectly. Are you keeping score or keeping time for each side or only for your own side?
Yes, I'll be
Your
keeping
Honor.
score for both sides.
Okay, then I want for you to confer basically, well, I guess we have to do it in open court. given the at halftime, I want to be sure how close we are, and I will resolve any differences at that point, and then also at final. Okay, is everybody okay with that?
Your Honor, I was planning on after each section that was timed, direct messaging my other timekeeper
Oh,
to her with times and then posting the agreed upon time.
yeah,
public.
yeah. And if there is in fact a dispute, I'll resolve it. Thank you very much. Well done. We can use the technology to assist ourselves here. Let me see. We already have introductions of team members. At this point, we are to swear in everyone. I do not expect you to stand because that's cumbersome. But if you will, if I can have the team members to please raise their hands. Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
You can nod your heads, that's fine. All right, now for the witnesses. Witnesses, raise your hands. The others team members can put their hands down. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Yes, very well. And now you can place your hands down. I don't see any gallery members, but gallery members, if you would raise your virtual hands, please. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? If you do not so affirm, then please let me know now. All right, scoring panelists, if you would raise your virtual hands as well. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yeah.
Good. Thank you so very much. All righty. Are there any housekeeping matters that we have to handle before we begin?
Yes, Your Honor. The plaintiff has several preliminary matters I'd like to attend.
Very well. And since you, sir, are at a distance and it's hard for us to recognize you, it's just a feature of the layout of the way of the room you're in. Please identify yourself before you speak on Team Stanley, please.
Yes, Your Honor. My name is Marcus Quinton.
Very well, sir. Mr. Winton, you may proceed.
The plaintiff has made efforts to be in the best possible internet capabilities. However, if at any time, Your Honor, or any of the scoring jurors cannot hear or see us, feel free to interrupt us at any time.
Oh, trust me, I will.
We ask that Dakota Weers be our advisory witness and therefore be seated at counsel table since he is the plaintiff in today's case.
That's granted.
For the record, witnesses will not be sequestered pursuant to Rule 5.3.1 of the Rules of Competition and will be present for the entirety of today's trial.
That's the way the rules read, so that's the way we're going to do it.
This time, may my trial technician post a copy of the stipulations, court-approved jury instructions, and pre-trial motion for Your Honor and scoring jurors?
Yes, please. You can post that if you like. I've already read it all.
This time, we would like to address opposing counsel and ask if they are willing to stipulate to two new facts. The first one being that Lush Fertilizer manufactured a product containing a chemical compound known as Drufo, and the second stipulating to the admission of Exhibit 1, since it is not in dispute that that is the packaging of Lush Fertilizer.
Okay, stipulation 1 is that the product contained Druco.
Yes, Your Honor. Lush Fertilizer manufactured a product containing the chemical compound known as Drufo.
Is that stipulated or not?
Your Honor, at this time, we would like to introduce that as a stipulation since it's not in dispute.
Well, I didn't hear the whether it was stipulated or not. counsel for Lush Fertilizer.
Oh,
I'm sorry, go ahead.
my apologies, Your Honor. The defense has no dispute with that stipulation.
Okay, then that's a stipulation. All right, then stipulation 2, restate it, please.
The admission of Exhibit 1 into evidence as it is not in dispute and we have a good.
Exhibit 1 stipulated into evidence. Okay. All right, counsel.
Your Honor, we disagreed to the admission of Exhibit 1 as opposing counsel should have to lay foundation before admitting evidence.
All right, you have a stipulation on one, but not on the other.
Thank you, Your Honor.
Very well. Any other preliminary housekeeping matters?
Your Honor, as the plaintiff has a good faith belief to the admission of Exhibit 1, we ask that we be able to reference it during our opening statements.
You can speak to exhibits during your opening statement. Either side can always do this, but you run the risk, obviously, that if Exhibit 1 is in fact not admitted for whatever reason, then you have a little bit of a problem with the jury. But if you have a good faith belief that it will be admitted, then I will permit it.
Just to clarify, we are able to show a copy during our opening statement.
Since it's not admitted before the jury, I think you can describe it, but not display it.
Yes, Your Honor.
Thank you.
Can the court clarify whether it intends to constructively read the jury instructions prior to or after closing argument?
You say constructively read your instructions when?
Prior to or after the closing argument?
It's always done before closing arguments, but you can do it you say constructively, so it will just be as if it actually happened. Is that what your goal is?
Yes, Your Honor.
Very well. Any objection to that?
No objection, Your Honor.
Okay, then that'll be permitted. Sure.
Your Honor, we'd just like to clarify a few mechanisms and procedures of today's online trial.
Very well.
Pursuant to Rule 7.4, stating that witnesses should have all case materials in front of them, we ask that every witness have a copy of every exhibit and their affidavit face down in front of them, so that either counsel may reference this while making it clear which exhibit or affidavit they are referencing, and to lay foundation for its admission.
Well, I think each witness should have enough exhibits to be questioned about them by either side. So yes, I don't see a problem with that.
We ask permission to move about our virtual well during examinations as well as during opening and closing argument.
Yeah, that's fine, but understand that you're on camera, and the more you move, maybe the more confusing it might be for the rest of us. Just keep that in mind. Normally my instruction is don't crowd the witness, but since, well, that's impossible in these proceedings, then I think that's probably okay.
Yes, Your Honor. Finally, pursuant to Rule 5.4 of the Rules of Competition, we would like to reserve any time remaining at the end of our closing argument for rebuttal.
Of course.
With that, Your Honor, the plaintiff is ready to proceed to trial.
Very well. Any preliminary matters on behalf of the defendant, Ms. Hobson?
Yes, Your Honor. First, we request that the pretrial ruling on November 1st, 2021 be recognized.
Yes, of course. I read it and recognize it.
And then finally, we would ask that if there are any technical difficulties, that time will be stopped for both sides.
I think we have to do it that way.
That is all, Your Honor. Thank you.
Very well. If you can have your first witness take the witness stand now, please.
Your Honor, prior to examinations, we're supposed to do opening statements.
Of course, of course. What was I thinking? Yes, please. Who is going to offer our opening statement?
I will be for the plaintiff, Your Honor.
Very well.
May it please the court.
Very well, you may proceed.
Today's case is about profits being put before people. This is Dakota Weirs. He's 20 years old and he has been diagnosed with non-Hodgkin's lymphoma. He will have to sit here today suffering and in pain. He has chest pains, shortness of breath, and he is tired all the time. But it wasn't always like this. He used to play piano and he was good. So good, in fact, that he got a full ride scholarship to Juilliard. He grew up with his twin sister, Skylar Weirs. They did everything together, at least until Dakota was 14. That's when he took a job at Haven Landscaping using Lush fertilizer. After years of working with their product, he realized that something was wrong. The diagnosis changed everything and crushed many of his hopes and dreams. Lush fertilizer prioritized profits over people, and it cost Dakota Weirs his future. As the plaintiff in today's trial, we have the burden of proof. We have to prove that it's more likely than not that Lush fertilizer negligently caused Dakota Weirs' non-Hodgkin's lymphoma with their product. And that because of that, Dakota suffered non-economic damages, including mental and physical pain and suffering, emotional trauma, emotional stress, distress, inconvenience, and impairment to his quality of life. We will meet our burden because Lush fertilizer prioritized profits over people, and now they need to be held accountable. As you listen to the testimony in today's case, you will learn that Lush fertilizer contains a compound called root fiber. This is the secret to their success, as it's an incredibly powerful bonding agent. You will also hear from a former employee of Lush, Carson Durst. She will tell you that Lush fertilizer knew that their product was dangerous, yet still chose to release it to market. You will also learn that Lush fertilizer knew how to make their product safe. All they had to do was to bake it. But their CEO, Blake Doncourt, thought that it was just too expensive. Once again, Lush fertilizer prioritized profits over people, and today you get to hold them accountable. As you listen to the testimony in today's case, keep in mind that the defense has their own burden. Instead of simply saying that their product does not cause cancer, they have instead asserted that Dakota Weirs is responsible for his own cancer because of the way that he used their product. They will have to prove by preponderance of the evidence that the way in which Dakota used their product was unreasonable, but more important, that if used in the way that the defense says is reasonable, that limits their product's ability to cause cancer. As you listen to the testimony in today's case, ask yourself why the defense is choosing to call a 20-year-old journalist if they had an actual expert to tell you that the product is safe. You will also hear from Dr. Casey Rogers, a toxicologist and the only credible expert in today's case. She will tell you about a study that she conducted on the effectiveness of the personal protective gear that the defense recommends. The results of her study are inconclusive, meaning the science will not allow the defense to meet their burden, and blaming the victim just won't work. All that Dakota Weirs wants is to regain a small portion of what was taken from him. The maximum that we can ask for by law is $500,000 in non-economic damages. At the end of today's trial, my co-counsel, Ms. Feeney, will ask that you hold Lush Fertilizer accountable, finding them solely negligent and awarding Dakota Weirs $500,000. Thank you.
Very well. And a opening statement on behalf of Lush.
May I proceed?
Hang on just a second. Let me make a note here. Let's see, that's going to be. Yes, Ms. Giselle, you may now proceed. Thank you.
Thank you, Your Honor. Good afternoon, Your Honor, counsel, and members of the jury. My name is Danny Gazzelli, and I represent the defendant, Lush Fertilizer, in this case. The counsel for the plaintiff just told you the case is about profits over people. But in actuality, this is a case about relying on science over speculation. It is the sad truth that the plaintiff has been diagnosed with non-Hodgkin's lymphoma. Yet, we are not here to debate this diagnosis, but rather the cause. Mr. Dakota Weirs is here attempting to prove that his use of a Lush fertilizer containing Drufo is the cause of his non-Hodgkin's lymphoma. The plaintiff has to support this conclusion, but the evidence, the science, will show that this is simply not true. While we acknowledge Mr. Weirs' terrible disease, you are being asked today not to determine whether Mr. Weirs has cancer, but whether his cancer was caused by Lush Fertilizer's product. And ladies and gentlemen, today the evidence you will hear does not support the plaintiff's conclusion. The burden of proof today falls on the plaintiff. They have to prove by a preponderance of evidence, meaning it is more likely than not that Lush Fertilizer failed to exercise reasonable care in the production and use of their fertilizer. At the conclusion of this case, we will ask you to find that the plaintiff failed to meet this burden. The defense will show the extensive research put into Drufo and every step taken to ensure its safety. You will hear that there is no credible evidence linking Drufo to non-Hodgkin's lymphoma in humans, despite the plaintiff's efforts to tell you otherwise. In order to disprove the plaintiff's claim of negligence, we will present 3 witnesses. First, you will hear from Lush's CEO, Blake Doncourt. Doncourt will testify to the time and energy she has put into this company, ensuring that Lush is sustainable, successful, and environmentally friendly, all while providing cutting-edge products to the public. Her testimony will show that through Lush's extensive research, development, and testing of Drufo, there were 0 scientifically based concerns about any harmful effects. Next, you will hear from Skylar Weirs, Dakota Weirs' twin sister and an expert in the agritech industry. She will testify to not only the benefits of Drufo, but how it's the safest fertilizer on the market. Her testimony will describe how her Drufo-specific research found that it was a complete myth that there were any harmful side effects to the use of Drufo. Last, you will hear from Dr. Devin Williams, a toxicological specialist who has worked for Lush for nearly a decade. She will not only testify to the fact that this data showed that Drufo had no correlation to any serious health conditions, but also share her expert opinion on why the only research the plaintiff has provided regarding Drufo being carcinogenic is scientifically flawed. Members of the jury, if you hear this scientific testimony and still decide to rule on the plaintiff's side of speculation, you will then be asked to consider whether the plaintiff's own conduct contributed to his injuries. It is up to you to determine if Mr. Dakota Weirs was also negligent, and today, the defense will show that Dakota Weirs was, in fact, negligent. Mr. Weirs himself will testify to the fact that he did not follow the manufacturer's safety recommendations or the safety instructions from his employer. You will also hear from the plaintiff's expert witness, Dr. Rogers, who will testify that their recommendations regarding Drufo were the same as those Mr. Weirs failed to follow. We recognize Mr. Dakota Weirs' anger at his diagnosis, but in this anger, he is scapegoating Lush, an upstanding company with products that have no carcinogenic effects. The plaintiff failed to consider the many other fertilizers that were used during his landscaping career. In fact, they failed to consider any other possible causes of his cancer. Because of this, the evidence the plaintiff will present will be rooted in speculation. And so, we ask that you rule in favor of the science and find the defendant not liable for negligence in this case. Thank you.
Thank you very much. And if you can call your first witness to the stand, please.
Your Honor, the plaintiff calls Dr. Casey Rogers to the stand.
Dr. Rogers, you have been sworn already. Please do take the stand. See who's doing the examination of Dr. Rogers.
My name is Marcus Winton, and I will be conducting the.
All right, Mr. Winton. All right, just give it a second or two so that the scoring panelists can get their work done, and then I'll let you know.
Yes, Your Honor.
Very well, you may proceed.
Good afternoon. Could you please introduce yourself to the jury?
Good afternoon. I'm Dr. Casey Rogers, and I'm a toxicologist.
What exactly was your role in today's case?
I'm here to talk about Lush Fertilizer, one of their products called Drufo, and their connection to Dakota Weird's non-Hodgkin's lymphoma.
Could you take a look at Exhibits 6 and 7 that should be in front of you? Dr. Rogers, what are these?
Exhibit 6 is a copy of my current curriculum vitae, and Exhibit 7 is a list of my publications.
Are both of these documents fair and accurate to the best of your knowledge?
Yes, they are.
And is it a regular part of your job to keep them up to date?
It is.
Your Honor, at this time, I move to admit Exhibits 6 and 7 into evidence.
Any objection?
Yes, Your Honor, hearsay.
As to which?
Both Exhibit 6 and Exhibit 7, Your Honor.
Very well. Can you respond to that, sir?
Your Honor, this is hearsay, but it fits hearsay exception 8036, a record of regularly conducted business, as Dr. Rogers has testified to being the creator of these documents, it being a regular part of her job to keep them up to date, and these documents being the up-to-date version of those documents.
Response.
Yes, Your Honor, I don't believe that opposing counsel has laid proper foundation for these exhibits to fall under that hearsay exception.
Yeah, I'm not sure they fit under that particular hearsay exception, but I'm not sure they're hearsay either. This is an expert witness. This is his credentials. Counsel, do you have any belief that these are false documents in any way?
No, Your Honor.
I wasn't asking you. I was asking the one objecting, Ms. Giselle.
No, Your Honor.
All right, very well. I'm going to admit them over your objection. You may proceed.
Your Honor, may my trial technician publish to the jury by both displaying on screen and dropping copies of the documents into the chat?
Yes.
Now, Dr. Rogers, looking at Exhibit 6 here, could you explain what your current occupation is?
Of course. I'm currently a professor in the Horticulture and Entomology Department at the University of California at Berkeley, and I'm also a faculty researcher in the Environmental Chemistry and Toxicology lab there.
And still looking at Exhibit 6 here, could you tell us about what training you received to hold this occupation?
Yes. I earned my bachelor's degree in agriculture and chemistry from Colorado State University. And then I was a research analyst for many years before earning my PhD in agriculture and entomology from UC Berkeley.
This time I'll ask my trial technician to switch to displaying Exhibit 7. Now, could you tell the jury a little bit about the research that you've conducted?
As you can see, I've published quite a lot of research, but many of those are specifically around Drufo.
My trial technician may now stop displaying the exhibits. Dr. Rogers, you mentioned being a toxicologist. What is that?
Well, the role of a toxicologist is to determine if there are any negative health effects associated with certain products. This often means that we look at a certain individual situation and the diseases they might have and work backwards until we can find out the source of that disease.
And without stating any expert conclusions, did you come to any conclusions regarding today's case?
Yes, I did.
Your Honor, at this time, I ask the court to recognize Dr. Casey Rogers as an expert in toxicology.
Any objection of voir dire?
Yes, Your Honor. Permission to perform a voir dire.
Yes.
Permission to proceed.
Yes, please go ahead. Thank you.
Sorry. Dr. Rogers, you are not a pre-med major, correct?
No, I'm a toxicologist.
You have no medical degree?
No medical degree specifically, however, I am a toxicologist.
Advanced education in medicine?
No,
And no experience working in the medical field, correct?
no, I don't diagnose patients or anything of the sort.
Your Honor, based on the witnesses' responses, I ask that any expert testimony is limited to exclude rendering a medical opinion, including any expert testimony concerning alleged ways in which Drufo could supposedly affect a non-Hodgkin's lymphoma diagnosis.
Response.
Your Honor, as the witness has just testified, being a toxicologist includes looking at patients' case files and the toxins that they were exposed to and coming to conclusions on whether the two are correlated. That is well within her field of being a toxicologist, which she is more than qualified for under Rule 702.
Ms. Giseli?
Yes, Your Honor, if I'm not mistaken, this witness is specializing in toxicology surrounding pesticide chemistry, not toxicology and its effects on the human body. Therefore, I stand with my objection.
I'd like to have a response to that before I rule. Please respond.
Your Honor, the witness has testified to looking extensively on the effects that Drufo could have on people. She in fact conducted a study regarding that, as well as having the necessary experience to render conclusions that will be useful for the trier of fact in today's case, pursuant to Rule 702.
Yes, what troubles me is that toxicology is a medical field, and this person has no medical training. I would admit her as an expert in pesticide chemistry, metabolism and mode of action of organic toxicants in insect biochemistry. I think I would exclude as far as toxicology goes, being as that's a medical field requiring medical training. So I'm going to permit it on that basis.
Thank you, Your Honor.
You may proceed.
Yes, Your Honor. Dr. Rogers, you mentioned being concerned about Drufo. Could you tell us why?
Of course, when Drufo was first introduced to the market, it seemed as if it hadn't enough safety studies done on it, as the window for safety testing was extremely small. Only a few years after it was released to the market, I actually began doing my own studies on Drufo.
Could you tell us a little bit about that study?
Of course, there's one in particular I want to talk about, and it actually had two separate parts.
Okay, let's start with the first part of that study. What was the goal?
The goal was to determine if there was a link between using Drufo in lush fertilizer and being diagnosed with cancer. And if there was a link, how strong that link was.
How did you go about determining if there was a link?
I separated people into three separate groups. The first group had a high level of exposure to Drufo. These were people like farm laborers and other agricultural workers. The second group had more moderate exposure to Drufo, like casual gardeners. And the third group had no exposure to Drufo. This was the control group.
Okay. What exactly does exposure mean in the context of your study?
To be exposed to something means to be in contact with it through touching it or breathing it in.
And what were the results of those that were exposed to Drufo?
Unfortunately, the group with the highest exposure to Drufo was found to be 10 times more likely to be diagnosed with cancer as the control group, and 5 times more likely to be diagnosed with cancer as the group with moderate exposure.
Did your study identify the types of cancers typically associated with the use of Drufo?
Yes, it was most often endocrine and exocrine cancers.
Okay, you made an objection. Please go ahead.
I believe this testimony is outside the scope of the witness's expertise.
Response?
Your Honor, the witness is not rendering an expert opinion under 702, and she's simply stating the results of what her study showed.
Response?
Your Honor, the witness is testifying to specific endocrine and exocrine variants of cancer, which I believe falls outside of their expertise today.
I'm going to overrule the objection. I will allow the testimony and you can test it upon cross-examination. So objection overruled.
Thank you.
Did you get a chance to finish your answer?
I was just saying that the cancers that were most often diagnosed were endocrine and exocrine cancers. Non-Hodgkin's lymphoma is an example of an exocrine cancer. It's also environmentally based.
You know, I want to move on to that second part of the study. Could you tell us what the goal of this part was?
The goal of the second part of the study was to determine whether or not using protective gear would help limit the risks of being diagnosed with cancer.
And what were the results of this second part of your study?
The second part was actually inconclusive. This means that we have no way to tell whether or not wearing the protective gear would or would not limit the risks of using Drufo.
Why was your study deemed inconclusive?
There were 2 reasons. First, there wasn't sufficient time to study that part. And second, workers aren't usually provided with that kind of protective equipment.
So is it common in the agricultural industry for people to wear the types of protective equipment that your study was testing for?
No, and that's a big problem with the industry as a whole. They don't monitor their employees to make sure that they're wearing the proper protective equipment.
Objection, speculation.
Your Honor, this is not speculation, as this witness is an expert under Rule 702, and this falls under her 702 expert opinion. She was tendered as an expert in pesticides and agriculture.
Yes, but you have not laid a foundation for her ability to know what she has just testified to concerning what happens with employees out in the industry. You might want to lay that foundation.
Thank you, Your Honor.
Your Honor, just to clarify, was that objection sustained?
Yes, it was.
Dr. Rogers, do you look into the agricultural field at all?
Yes, that's my job. As you saw in Exhibit 7, I've done a lot of studies, and that means being around agricultural workers.
So is it common in the agricultural industry for people to wear the types of protective equipment that your study was looking at?
No, it is not. As I said, that's a big problem.
Finally, did you look into anything specifically surrounding today's case?
Yes, I did. I looked at Dakota Weir's medical records and
And are these the types of things that experts in your field would reasonably rely upon?
yes.
Your Honor, what have you learned from Dakota Weir's medical records?
I learned that he had been diagnosed with non-Hodgkin's lymphoma only a few years ago.
And what did you learn from his employment records?
I learned that his level of exposure to Drufo was very similar to the group with the highest and most prolonged exposure to Drufo in my study.
And what was the result of people being exposed to high levels of Drufo?
They were much more likely to be diagnosed with cancer.
Thank you, Your Honor. I have no further questions at this time.
Very well. Cross-examination.
Yes, Your Honor, permission to.
Not quite yet. Hang on just a second. Very well, you may proceed. Thank you.
Thank you, Your Honor. Let's start by looking at your expertise surrounding Drufo. When looking at toxins, they are absorbed through the skin, correct?
Be absorbed in a variety of ways. They can be absorbed through the skin or through lung tissue.
And because of this, you believe that those who use Drufo should wear long sleeves, right?
Yes, it would be an extra precaution.
And long pants.
That's correct.
All measures taken to avoid absorption through the skin, correct?
Yes.
In your expert opinion, you believe that those working with Drufo should wear a mask.
Generally, yes. However, there isn't enough hard science to be sure that that actually would prevent the risks of using Drufo.
And this is to avoid respirating the chemical, correct?
Yes.
And these are all precautionary safety measures those using Drufo should take, right?
Yes.
Because in your expert opinion, these measures would reduce exposure and related risks of Drufo, correct?
Theoretically, as I said, there isn't enough hard science to show that it really does limit the risks of using Drufo.
But in your expert opinion, using these measures would reduce exposure and related risks of Drufo, correct?
I just talked about how my study was inconclusive, so I can't say that.
All right. In your review for the case, you found that Dakota Weirs used Drufo without any skin protection, correct?
There are occasions on which Dakota Weirs did not use protective equipment.
Or any kind of face covering?
That's correct.
Let's transition to looking at your study. This was a study that you personally conducted, right?
Yes,
You looked at 3 groups of people,
that's right.
a group who was never exposed to Drufo,
Yes, that was the control group, or group 3.
a group who was exposed occasionally,
Yes,
and a group who was regularly exposed.
that's correct.
Those exposed to Drufo contained farm laborers and gardeners, correct?
Generally, yes.
Of course, occupationally, farmers and gardeners are typically exposed to other pesticides during their work, right?
Not in this case, no.
And you didn't provide us any information about possible exposure to pesticides during your study, did you?
It's all written in the report and the publication's listed on Exhibit 7.
But here today, you did not provide us this report or the actual publication for us to verify this information, correct?
I believe it's available to anyone who wishes to look at it.
But today, here in court, we do not have a copy of that information, correct?
I don't believe so.
Farmers and gardeners can also be exposed to other kinds of fertilizers during their work, correct?
Not in this case. I followed proper experimental protocol and made sure that I was controlling for confounding variables.
So you're saying you isolated the variables, correct?
Yes, I made sure that I was only looking at Drufo specifically and that other things wouldn't impact the results.
But yet again, you didn't provide us any information on how you isolated these variables today, did you?
I was following proper scientific and experimental protocol. Again, it's all written in the report.
That was not my question, Dr. Rogers. I'm saying that here today, you did not provide us the information on how you isolated these variables, correct?
I did provide you with the name of the report.
You found an increase in serious health conditions for those exposed to Drufo, right?
Yes, I did.
Which included these farmers and gardeners.
That's correct.
But based on the information you provided here today, we have no way of knowing that drufa was the only chemical difference between these three groups, right?
Once again, it's all contained within the report.
So you provided us here today with sufficient information about every other chemical that they did or did not use in your study. Is that what you're stating?
Yes, in my statement, I included all of the relevant information about Drufo and especially Dakota-Pierce.
So could you point to me in your witness statement where you detailed these other chemicals that were or were not used during your study?
Again, I didn't specifically state the different chemicals because there were none.
All right, but you didn't state any information about there not being any other chemicals, correct?
I followed proper experimental protocol once again.
And this means that the increase in serious health conditions cannot be attributed to Drufo specifically, correct?
It can be contributed to Drufo specifically. Excuse me.
Thank you. No further questions.
Very, very well. Any redirect?
Your Honor, may I inquire as to how much time I have remaining before I decide?
You have 17 minutes and 53 seconds remaining.
Briefly, Your Honor.
Very well. Hang on just a second. Don't start the time quite yet. Very well, you may proceed.
Dr. Rogers, are there standards and protocols in the scientific community for the validity of studies?
Absolutely.
And did you follow all of these?
Of course, I wanted to be sure that the results of my study were as accurate as possible.
Thank you. No further questions, Your Honor.
Very well, you may be excused. Please call your next witness.
Your Honor, the plaintiff calls Carson Durst to stand.
Say that name again.
The plaintiff calls Carson Durst to the stand.
Okay. Unclear. You have been previously sworn. You remain under oath. Who is going to be performing the examination, please?
Eva Simpson, Your Honor.
Very good. And you may proceed.
Good afternoon. Could you please introduce yourself to the jury?
Hi, I'm Carson Durst. I work as a product developer at Terrace Greenery and have for about 15 years since I left Lush Fertilizer.
Now, Ms. Durst, I'd like to give a brief timeline of your experience for the jury. How did your career first begin?
After high school, I went to Arizona State University and graduated with a bachelor's in chemical engineering. At the time, I was actually super lucky, and my best friend's dad was CEO of Lush Fertilizer, which helped me get an internship right out of college.
Tell us about that.
Honestly, when I was hired as an intern, I really just thought I'd be running around the office making coffee or something. But instead, I was assigned to an entire new flagship product called Drufo.
And what is Drufo?
Drufo is what Lush Fertilizer's success is really dependent on. It's a compound binding agent, which basically means it's sticky.
And did you find any outside research of Drufo?
Yes, I did. When I started out the company, I was just an intern, so basically what I did was research. In particular, I found one pretty concerning study from England and recorded it right away.
Ms. Durst, I'd like to direct your attention to Exhibit 3. Should be on the stand with you?
Yes, give me one moment. Yes, I have it here.
And this is that same study?
Yes, it is.
Your Honor, at this time, I ask that my trial technician be allowed to display Exhibit 3 as it's already been admitted.
Let's see, has Exhibit 3 been admitted?
Your Honor, I believe it has not been admitted.
I don't believe it has. You offer its admission.
Yes, Your Honor. Ms. Durst,
Objection.
could you please tell the jury?
Yes.
Hold on. Objection.
Yes, Your Honor, hearsay.
Response.
Your Honor, is opposing counsel objecting hearsay to the study?
Sounds like it. Exhibit 3.
Your Honor, this is not hearsay, as this study is a statement of a party opponent, as this study was found by Carson Durst on behalf of Lush Fertilizer, as she was an employee of Lush Fertilizer, pursuant to Rule 801 D2D.
All right. 801 D2. I'm not sure you have laid that foundation quite yet. Please, I will sustain the objection for now. If you would like to lay a further foundation, that might be appropriate, but I'll not quite admit it yet.
Thank you, Your Honor.
Ms. Durst, could you please tell the jury what this exhibit is?
Yes, this is the study that I found from England while working at Lush Fertilizer. I was a researcher at the time and documented it in my lab notebook.
And is this study fair and accurate to the best of your knowledge?
Yes.
Your Honor, at this time, I ask that Exhibit 3 be admitted into evidence.
Objection.
Yes, Your Honor, hearsay.
Your Honor, this again fits hearsay exception 801 D2D, as this study was found by Ms. Durst as part of her employment of Lush Fertilizer, recorded as part of her employment of Lush Fertilizer, making this a statement of a party opponent.
I'll admit it on that basis. Exhibit 3 is admitted.
Now, why was this study concerning?
Well, there are multiple different parts of the study that were concerning, but first you have to understand a little background information about it. Now, this study was conducted by 4 separate scientists, as you can see here, about C3NO9P. That's just the chemical compound that makes up most of drufonap. Now, in the introductions column, you can see right about here, it concludes that this substance is carcinogenic, but it gets even worse. By the end of the conclusions column, right here in the 4th paragraph, it basically says that because of these significant findings, separate tests need to be done not only on women, but children to make sure that this substance is safe, which is why it was so important Lush Fertilizer took it seriously.
Your Honor, I ask that this exhibit be published to the jury.
Yes.
Will my trial technician be allowed to display it on the screen?
Yes.
Thank you. Now, what did you do when you found this study?
Well, because of the amount of concern I had from the results in this study, I wanted to shout through the rooftops to Lush that we had a really big problem. But that's just not how the company worked. Instead, I recorded in my lab notebook, as I was supposed to do with everything, following proper protocol. They had me write everything in there, good, bad, insignificant. Now, this might not sound like a problem, but now that I've worked for a different company, the real concern is with this system, there's no way to prioritize life-threatening findings like cancer for our customers.
Thank you, trial technician. That can be taken down. Now, Ms. Durst, how did Lush Fertilizer react to you putting this study in your lab notebook?
They didn't react at all. I never heard anything. It was complete radio silence. I was just an intern at the time and didn't really have much experience, so I didn't really know what to do. I tried to keep doing my work, hoping they'd bring it up.
And what happened after this?
Well, they never brought it up, but I did keep doing my work and was promoted to product development engineer as they started a new study about Trufo.
Did this mean that Lush Fertilizer was taking safety concerns seriously?
No, not at all. This new study, if anything.
Objection, Your Honor, speculation.
Response?
Your Honor, this is not speculation pursuant to Rule 701, as Ms. Durst is testifying to her perceptions and observations working in the company of Lush Fertilizer, and hence she would know what the company culture was like and how Lush Fertilizer reacted to her findings and studies.
Response?
Your Honor, I don't believe that Ms. Durst knows what Lush is thinking or speculating about these studies that she gave them.
I will allow her to testify concerning her personal observations on that topic, and we can restrict it to that. So I will partially sustain.
Thank you, Your Honor.
With instructions.
Ms. Durst, did you get a chance to finish your answer?
No, not exactly. Based on what I observed at the company, they weren't taking the concerns seriously at all. By this point, the company from the first study had already heard concerns that Drufo was carcinogenic. But the second study seemed like they were just trying to cover it up. You have to understand, when you work for a company like Lush that continuously prioritizes profit over people, they go into these studies already knowing the results.
Ms. Durst, I'd like to direct your attention to Exhibit 4 in front of you.
Yes, I have that also here.
What is this?
This is the email that I got concerning what we would be doing in this new study and laying it out. You can see at the top, it's sent from my supervisor on behalf of Lush Fertilizer to the entire Drufo team.
Is it fair and accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I ask that Exhibit 4 be admitted into evidence.
Objection?
Yes, Your Honor, hearsay and authenticity.
Response as to both of those, please.
Yes, Your Honor. This is not hearsay for the same rule 801D2, as this email was sent by an employee of Lush Fertilizer on behalf of Lush Fertilizer, making this a statement of a party opponent being Lush Fertilizer. This also is authentic, as Ms. Durst has testified that it's fair and accurate to the best of her knowledge. And on top of that, stipulation 1 states that all signatures are authentic. And at the bottom of this email, Jerry Langley, an employee of Lush Fertilizer, signed his signature, making this authentic pursuant to Rule 901.
The only concern I have is authenticity at this point. The signature at the bottom is a machine generated signature and not by hand. And so that I'm not sure is good enough to qualify as actually a signature. So would you ask a few more questions on authenticity? I will reserve the, I'm going to overrule the objection as to hearsay, but I'll reserve my ruling on authenticity. Please ask a few more questions if you would, please.
Yes, Your Honor. Ms. Durst, who was this email sent from?
Email was sent from my supervisor to the whole Drufo team. It's exactly how it was when I got it on September 18th and immediately printed it out.
And is this email, as you received it, and fair to the best of your knowledge?
Yes, everything from the confidentiality notice on the bottom to the recipients.
Your Honor, at this time, I ask that Exhibit 4 be admitted into evidence.
Any further objection and any response to the latest bit of testimony?
Yes, Your Honor. Due to the declarant of this email, Jerry Langley, not being present, I stand by my authenticity objection.
Very well. I am going to, I think, admit it under the grounds it has been offered, and you can obviously question further on cross-examination. So your objection.
Thank you, Your Honor.
And may my trial technician publish this to the jury and display it on the screen?
Yes.
Now, Ms. Durst, what was the gist of this email?
Well, when I got this email, I actually found it pretty concerning. Now, as I was saying before, at this point, the company had already heard concerns that Drufo was carcinogenic from our first study. But you can see in the second line right here, it puts in quotations conclusive, basically saying that the results we had already found, they didn't validate. But it got even weirder. As I kept reading, it basically said that with this new study, if we found the same results, we were to bring them directly to management and not record them, which was completely bizarre. Lush had always told us to write down everything and not bring our concerns to management. So it basically seemed like they didn't want a paper trail.
And what happened after this?
No matter how concerned I was that Lush fertilizer wasn't going to validate any studies or any new findings we found, it was my job. So we went on and did the research and found even more concerning information.
And how is that?
Well, we did the study in December. Everyone gathered in the conference room to share findings to our manager. My specific group hadn't found any new concerns other than the carcinogenics and further testing that need to be done for children and women. But specifically, one scientist that worked for Lush told the company that not only—
Objection, Your Honor, hearsay.
Response?
Yes, Your Honor, this is not hearsay, as this statement was made as an employee of Lush Fertilizer on behalf of Lush Fertilizer at a meeting where Lush Fertilizer was having them express their concerns about what they have been finding, making this a statement of a party opponent pursuant to Rule 801 D2D.
Response?
Your Honor, once again, I believe the declarant is not present in this court today.
Well, that's true.
Therefore, it is not a party opponent that was saying this statement.
Well, it still could be a party opponent. Counsel, I'm going to allow it, but within limits. Don't go too deeply into statements made by others unless they are quite relevant, please.
Thank you, Your Honor.
Yeah. Misters, did you get a chance to finish your answer?
Not exactly. Basically, this scientist that worked on the Drufo team with me specifically told management that not only had they found the same carcinogenic concerns, but now they had found a direct possible link to non-Hodgkin's lymphoma, which is a pretty serious cancer. But the company didn't even really seem to care.
So just to be clear, this was the first scientist to find a link between Drufo and non-Hodgkin's lymphoma?
No, not at all. If you remember from Exhibit 3, the England study, there were 4 other scientists that specifically found this substance was carcinogenic and could cause lymphomas. So actually, this was the 5th scientist that Lush had heard from.
So despite hearing from 5 separate scientists that Drufo was linked to non-Hodgkin's lymphoma, did Lush Fertilizer do anything to change their product?
No, it really didn't seem like it. They never did any further testing like the England study said needed to be done, and they really didn't seem to do anything at all. A few months later, they came out with a study report, but it was totally misleading, covering up major pieces of information.
How was this study report misleading?
The study report didn't even mention non-Hodgkin's lymphoma and said that the suggestion of baking Lush fertilizer, which we had found was the best solution to eliminate carcinogenics, could be presented as going above and beyond when they had done no testing to ever determine that.
Now, Ms. Durst, based off your perceptions and observations, being an employee of Lush Fertilizer, were they taking the health risks of Drufo seriously?
No, not at all. From the beginning of my internship—
Objection, Your Honor. Speculation and foundation as well.
Okay, what foundation objection do you have?
I don't believe that Ms. Durst has laid the proper foundation that she can testify to the knowledge of whether they were testing or anything she just testified about.
Very well. Response to the objection.
Yes, Your Honor. This isn't speculation pursuant to Rule 701, as Ms. Durst is testifying to her perceptions and observations being an employee of Lush Fertilizer and knowing that they didn't change anything as she was an employee. Ms. Durst also Ms. Durst has also testified that she knew of Lush Fertilizer's chain of command, that she knew how they reacted to studies, and that as an employee, she knows what was going on within the company, so she can testify as to whether or not Lush Fertilizer was taking safety concerns seriously.
Okay. One last response, Ms. Hobbs.
Your Honor, I believe that we have validated that Ms. Durst was simply at the bottom of the food chain in Lush, and therefore she would have no way of knowing what the CEOs or the bosses were thinking about these studies.
Very well. I am going to allow the testimony under Rule 701 because it's rationally based upon the witness's personal perception. However, you are permitted to cross-examine on that. So your objection is overruled.
Thank you, Your Honor.
Ms. Durst, did you get a chance to finish your question about Lush Fertilizer taking safety concerns seriously?
No, not exactly. From what I observed as an intern and then later being promoted to a product development engineer, I never saw them take any concerns seriously. They never did any proper testing like the England study outlined, and they tried to cover up any findings we found that this substance was carcinogenic, never even doing a follow-up study after that initial report in December.
Thank you. Your Honor, I have no further questions.
Very well. Cross-examination.
Yes, Your Honor. May I
Okay.
proceed?
Not quite yet. Give us
Okay.
just a second here. All right, you may proceed.
Thank you, Your Honor. Ms. Durst, Ms. Doncourt's son, Charles, and you were lifelong friends, correct?
Yes, that's why I had the connection to get an internship.
You two were inseparable, even going to the same college together.
We grew up together. Really, the Doncourts were like the family I never had.
And after college, like most college students, you were inexperienced.
Yeah, that's why I decided to get an internship rather than just working a minimum wage job.
And like you just said, Charles, being a great best friend, put in a word with you with his mom.
Yeah, I was really lucky at the time.
And once you got to Lush, they made you sign a confidentiality agreement.
Yes, they did. In the first days of my employment, it was hard to remember so long ago.
And this is pictured in Exhibit 5.
I believe so. Would you like me to look?
Yes, please. Your Honor, let the record reflect I'm asking the witness and my opposing counsel to refer to Exhibit 5.
Record reflects.
Ms. Durst, is this the agreement between you and Lush?
Yes, it was signed on the first day of my employment.
And this is your signature at the bottom of the page.
Give me 1 second. Yes.
Is this a fair and accurate copy of what you remember?
Yes, it seems to be.
Your Honor, let the record reflect that at this time, I move for the admission of Exhibit 5 into evidence.
Objection.
Yes, Your Honor, this is hearsay pursuant to Rule 801, as this is an out-of-court statement being offered to prove the truth of the matter asserted.
Response.
Yes, Your Honor, this is not hearsay because under 801 D1, this document is the witness's prior statement since they did sign it and adopted it as their own.
I believe that is correct. It's there's no authenticity question either, so I'm going to admit Exhibit 5.
Thank you, Your Honor. Permission to publish Exhibit 5 with the jury?
Yes.
Ms. Durst, this agreement states that you cannot work for any company that would benefit from a disclosure of Lush's trade secrets, correct?
Yes, it does.
And I'm sure you understand this is a legal document.
Yes, it is.
Okay, now that we've covered that, let's go back to what happened while you worked at Lush. After 3 months at Lush, you had already become a product development engineer.
Yes, I worked hard as an intern and proved that I really deserved to be there.
But unfortunately, as time passed, your work became more and more criticized, right?
A few years later, yes, when I started to bring up concerns to the company.
And eventually, your higher-ups made you sign a performance improvement plan.
Yes, they did, but I really think it was just to silence me. My performance hadn't gone down.
And even Miss Doncourt, your lifelong mentor and close family friend, refused to intervene on your behalf, correct?
Yes, she did.
And as you said, this made you feel betrayed by Miss Doncourt.
Yes, she had always been there for me, and I really only went to her as a last resort. I had tried to follow the proper chain of command.
But you had a plan for revenge, to make Miss Doncourt feel betrayed in return, correct?
I wouldn't exactly call it a plan for revenge. No, not at the time.
So, Mr. Durst, are you saying that you did not say you had a plan for revenge?
Later on, yes, but I think you're mixing up dates.
Miss Durst, is that a yes?
Like I just said, yes, later on after getting brushed off once again.
Thank you. And you knew how much Miss Doncourt hated her competitor, Tara's Greenery, right?
I don't really know any employer that doesn't hate their competitors, so yeah.
And after the issues you'd been having, you applied for a job there.
I applied to a bunch of jobs in the fertilizer field. It's really what I knew at the time, and Tara's Greenery was a good fit.
But Tara's Greenery, along with these other fertilizer companies you just mentioned, would benefit from Lush's trade secrets.
I never planned to share trade secrets. I just wanted to be somewhere where they valued me.
Yes, but Miss Durst, even if you didn't plan on sharing them, which I'm sure you didn't, they still would benefit from these trade secrets.
If I had shared them, I guess, but I was never going to do that.
So you had broke your legal promise you had made, correct?
Yes, at the time I didn't remember the contract and we went through a whole dispute about it later.
Okay, thank you. Let's go back to your work at Lush. At Lush, you were part of the research of Drufo, right?
Yes, that's what I primarily spent my time on.
Yet you were not a scientist conducting experiments.
No, later on I was an engineer. That's what I had a degree for.
And you had no PhD.
No, that's why they had scientists that did. They had other researchers.
And as you were saying, you simply analyzed these studies, correct?
As a researcher, yes, I did. When I went on to be an engineer, I had a little bit of a bigger role in the company, but I still did some research on the side.
Ms. Durst, on direct, you brought up this notebook where you kept all your findings, correct?
Yes, they had everybody put everything down in their lab notebooks.
Yet, did you provide us with the notebook today in evidence?
That's not my property to give. That would be Lush Fertilizers.
So, Ms. Durst, are you asking us to simply take your word for all the contents of your notebook?
If I had no way of providing a lab notebook, that was my work at Lush Fertilizer. Like I said, I never planned on sharing trade secrets, so I never would have brought that with
Ms.
me.
Durst, that was not my question. I was just asking if you wanted us to take your word for these contents of the notebook.
I guess since Lush Fertilizer didn't provide it, you have to.
Thank you. Let's move on. You even say yourself in your statement that baking the fertilizer was said to be going above and beyond the safety standards.
I don't think I said. That's how it was presented in the study report that was totally misleading. That was one of the bigger issues of the conclusions.
But the study did present this, correct?
Yeah, that's how they presented it at the conclusion.
And Drufo, like many other things, being carcinogenic was just simply a possibility, but nowhere near being definite.
No, that's why Lush Fertilizer needed to do future testing. They just
Miss Durst, you even admit, based on what you saw in the report, that there was no specific mention of non-Hodgkin's lymphoma anywhere in the report.
Yes, after direct scientists had told them that there were specific concerns about this illness, they never even mentioned it.
Thank you, Miss Durst. I have no further questions.
Good. Redirect.
Before I make my decision, may I inquire as to how much time I have remaining?
Of course.
You have 6 minutes and 46 seconds remaining.
Your Honor, no redirect.
Well, you may step down. If we can have our next witness, please.
Yes, Your Honor. The plaintiff calls Dakota Beers to the stand. And my
Dakota
name is,
Weir.
and I will be conducting the direct examination.
Who is going to be conducting again?
Hannah Feeney.
Okay. Feeney, yes. You may proceed.
Yes, Your Honor. Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Dakota Weirs. I'm here today because I have cancer and I don't want anyone else to have to suffer like I have.
We know that Lush Fertilizer contains Drufo. Did you ever work with Lush Fertilizer?
Yes, I did.
When?
I used it when I was working for Haven Landscaping.
When did you work there?
I started when I was 14, just as a little side job to get some extra money. I mainly spray grass seed and spray fertilizer.
Would you be able to recognize the packaging of Lush Fertilizer if you were shown a picture?
Yes, I would.
I'd like to direct your attention to Exhibit 1, which should be on the stand in front of you. Do you recognize this exhibit?
Yes, I do.
What is it?
It's a photograph that my old boss from Haven Landscaping sent me of the packaging of Lush Fertilizer.
Is it fair and accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I move to admit Exhibit 1 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 1 is admitted.
Permission for my trial technician to publish to the jury via screen sharing in the chat feature.
Granted.
Mr. Weirs, using Exhibit 1, could you tell us about any warnings on the packaging relating to cancer?
There are no warnings relating to cancer. The most that you get is a caution for eye irritation, as you can see right up here. The only other thing is the user safety recommendations.
What are those safety recommendations?
Well, it's the same thing that you see on every generic spray fertilizer. Use a mask, gloves, and proper protective equipment.
Did anyone at Haven Landscaping follow those recommendations?
Generally, no. It was simply too hot outside to wear any proper protective equipment, and all we thought it could cause was eye irritation.
Thank you. Exhibit 1 is no longer needed. Mr. Weirs, did you personally follow those recommendations?
Although I tried my hardest to, as I said, sometimes it simply wasn't possible. We risked getting heat stroke.
Would you have worn the proper protective gear if you had known about any possibility that Lush fertilizer could cause cancer?
Absolutely, I would have. Getting heat stroke or eye irritation would have been much better than this horrible, horrible disease.
Tell us about your life before the diagnosis.
Well, I was always helpful and active in my community, and especially taking pride in my good grades. Even though that took up most of my time, I love playing piano. It's my passion and what I truly want to pursue as a career.
Tell us a little more about the significance of piano.
Objection, Your Honor, relevance.
Your Honor, yes, Your Honor. This is relevant pursuant to Rule 401, as it tends to prove the extent of the non-economic damages that Mr. Weirs has suffered in today's case. The plaintiff has to prove the type and extent of non-economic damages he has suffered. Specifically, this goes to emotional stress and emotional distress and trauma. As Mr. Weirs has testified that piano was his passion, and I anticipate that he will continue to testify that due to his diagnosis, he is no longer able to play piano. As such, this is relevant pursuant to Rule 401, and anything further goes to the weight, not the admissibility of this evidence.
Response?
Yes, Your Honor, I don't believe the plaintiff's hobbies are relevant to this case.
The non-economic damages can be based upon many things, and I think I will permit this as being relevant and material. So your objection is overruled.
Thank you, Your Honor.
Mr. Weirs, were you able to finish your response?
No, I was basically just saying, excuse me. I was basically just saying that I started off playing piano with my grandfather, and he was my mentor, and he was also a concert pianist.
Did you have any future plans regarding piano?
Yes, I did. I was offered a number of scholarships, but the main one was a full ride to Juilliard.
For those of us who aren't musically inclined, what is Juilliard?
Juilliard is one of the most prestigious musical colleges in the world. In my case, it's for piano.
Can you go to Juilliard anymore?
No. I was offered to defer my scholarship for up to 2 years, but that time period has passed by now. Not only that, I've lost out on so much time that I'm not physically able to play anymore, from the tremors to the bruising.
One of the things the jury has to consider today are the type and extent of the non-economic damages you've suffered. First, how has your quality of life changed since your diagnosis?
I never thought that I would be going from helping out to needing all of the help. I basically lost all of my independence.
Has this caused you any inconvenience?
Of course it has. I can barely even get up in the morning. And from the hand tremors to the bruising to the shortness of breath, everything has just made life so much harder.
Could you expand on your physical pain?
Well, from everything I mentioned, there's also this hole in lymph nodes in my neck, which sometimes makes it hard to talk. That and my depression has gotten much worse.
Has your illness caused you any emotional distress or trauma?
Of course it has. At this point, my future is just a hazy mess. I lie awake at night wondering what's going to happen. I don't know what my future looks like or if I can even honor my grandfather anymore, but either way, I can't let myself suffer like this anymore.
Thank you. Your Honor, I have no further questions at this time.
Very well. Cross-examination.
Yes, Your Honor, just let me know when you'd like me to proceed.
I will. Very well. You may proceed, Ms. Kozlowski.
Thank you, Your Honor. Hello, Mr. Weirs. My name is Kendall Kozlowski, and I represent the defendant in this case, and I'm going to be asking you a few questions. Let me just start off by saying my client and I have the deepest sympathy for you and your medical condition, but I do have to ask you questions, so just please let me know if it becomes too much for you to answer.
Of course.
Mr. Weirs, you started working for Haven Landscaping when you were 14. Does that sound right?
Yes, I did. I ended around age 18 or so.
So you'd say that you worked there for about 4 to 5 years.
It was closer to 4 years.
And in those 4 years, Lush fertilizer wasn't the only fertilizer that you used. Is that correct?
That's correct. So I used maybe 2 or 3 other fertilizers.
You worked with these other fertilizers and garden chemicals maybe even more regularly than you worked with Lush. Is that correct?
I would say that primarily we all worked with Lush. The other chemicals were more add-ons.
But you did work with these other chemicals. Is that correct?
For shorter amounts of time, yes.
And you testified that you did this indoors and outdoors.
Yes, we had a variety of clients.
And there were fertilizers that you used indoors that specifically had safety recommendations that they should only be used outdoors. Is that correct?
Generally, the ones that I use indoors advise that they could be used indoors, and same for the outdoor fertilizers.
Mr. Weirs, that was not my question. My question was, there were fertilizers that you used indoors that specifically had safety recommendations that they should only be used outdoors. Is that correct?
No, not generally.
Mr. Weirs, your boss even told you to always cover your face when you were working with chemicals. Is that correct?
Yes, we were all advised to.
But you didn't do that, did you?
There were times where I couldn't. Me and my coworkers all couldn't.
And you were told to wear long sleeves, but you didn't wear long sleeves.
Again, there were times where we couldn't. As I said on direct, we risked heat stroke, and that seemed like the worst thing that could happen.
Mr. Weirs, you were told to wear pants, and you didn't wear pants.
There were some times where I wore shorts, yes.
And I'd like you to turn your attention to Exhibit 1, which has already been admitted into evidence. Just let me know when you're there.
I have it.
Now, you say in your statement that there were no warnings on the fertilizer label, but it does say hazard on that label, and the common meaning of that word does imply danger.
Yes, the thing listed under it is eye irritation.
Mr. Weirs, I'd like you to draw your attention to the first 2 sentences under user safety recommendations. Could you read those for us?
It says, as with any spray fertilizer, utilize protective clothing that covers exposed skin. Would you like me to read on?
That's perfect, thank you. So as you just read, you were supposed to cover any exposed skin when you used any fertilizer.
Yes, generally I did.
And Mr. Weirs, as you just testified, you did not always do that, did you?
Not always, but neither did my coworkers.
Mr. Weirs, I'd like to talk to you now about your diagnosis. After you found out that you had cancer, you saw a story on the news about Lush fertilizer. Is that correct?
Yes, that's what originally piqued my interest.
And you were called back to when you were 14 and you remembered that you used Lush fertilizer among other fertilizers. Is that correct?
That's correct.
Finally, Mr. Weirs, earlier you said that you believed that your cancer was caused by Lush fertilizer.
Yes, I do, as Dr. Rogers has proven.
But Mr. Weirs, you didn't do anything to ever research any other chemicals that you used if they were carcinogenic. Did you?
No, but Dr. Rogers did review my employment records. So if she would have had any concern, she would have brought it up to me as my expert.
But Mr. Weirs, you sitting here right now don't know for certain that solely Lush fertilizer caused your cancer.
As I labels and there were no other warnings about non-Hodgkin's lymphoma, I didn't see any reason why they would have caused it.
Mr. Weirs, you just testified that Lush fertilizer was just one of many other fertilizers and garden chemicals that had warning labels that you didn't follow. Is that correct?
That's correct.
Thank you. No further questions.
Very well. Any redirect?
First, may I inquire as to how much time I have remaining?
Of course.
You have 40 seconds remaining.
Yes, Your Honor.
Your Honor, if I may, would I be permitted to stand for just a moment? It's getting too difficult to sit down.
Of course.
Thank you, Your Honor.
May I proceed?
You may.
Mr. Weirs, are you all right to answer questions still?
Yes, I am. It was just hurting a bit.
Why did you not always follow the safety recommendations on the packaging?
Well, as you can see, the worst that we thought could happen was eye irritation. Among that, if we were to wear long sleeves and pants while working outside in the heat all the time, this was a summer job, we risk getting heat stroke. Almost none of my coworkers wore it.
Thank you. I have no further questions at this time.
Very well. You may step down. Any further witnesses?
Plaintiff rests.
Well, any halftime proceedings?
The plaintiff does not have any issues at this time, Your Honor.
Any on behalf of the defense?
No, Your Honor.
Well, and the defense may call its first witness.
Your Honor, we call Ms. Blake Doncourt to the stand.
Blake Doncourt. You have been previously sworn. You are still under oath. Who's going to be doing the, Ms. Hobson, are you going to be doing the examination?
Yes, Your Honor.
Very well, thank you. You may proceed then.
May you please state your name and spell your last for the court?
Absolutely. My name is Blake Doncourt. It's Doncourt.
Miss Doncourt, what do you do for a living?
I work for Lush Fertilizer.
What do you do for Lush?
Technically, my official title is CEO, but honestly, at Lush, we're one big family, so I tend to steer away from the labels.
And what does Lush do?
We create fertilizer, but honestly, on a deeper level, we provide employment for genuinely very good people, and we create safe and sustainable products.
How long have you worked here?
Objection, Your Honor, may I be heard?
I'm sorry, I missed the objection. Say it again, please.
I object that this is that Ms. Doncourt's statement that Lush Fertilizer Incorporated creates safe products is improper lay witness testimony pursuant to Rule 701, as this statement requires expertise under Rule 702, which Ms. Doncourt does not have.
Response?
Your Honor, Ms. Doncourt is the CEO of Lush Fertilizer and was simply stating her opinion as being the CEO.
I get the objection. I'm going to permit the testimony. I suspect the cross-examination will focus on that as well. So objections overruled as for this.
Thank you, Your Honor. Ms. Doncourt, would you like me to repeat my question?
Yes, please. Thank you.
How long have you worked at Lush Fertilizer?
Since 2000, so over 2 decades, that would make it.
And what was Lush like when you first began working there?
It was practically unknown, so to speak. It was very, very small.
And today, what is Lush's position in the industry?
Well, we are very proud to be a market-leading company creating fertilizer. And, we just keep working our way up from the ground.
What are some of these accomplishments?
Well, we have won awards for a lot of our different accomplishments, like the SEAL Business Sustainability Award. But honestly, on a deeper level, my biggest accomplishment is just Lush in total. I mean, it's truly my pride and joy, and so many people have put so much effort into it.
Could you please tell the jury what makes Lush's products so unique among its competitors?
Absolutely. As I'm sure we're all very aware of Drufo at this point, it actually was originally created to reduce the number of nitrates that go into large bodies of water, for example, oceans, streams, lakes. So it actually has assisted us in fulfilling our sustainability goal. I mean, much like our values, we want our products to be just as eco-friendly.
Since Drufo is so important, let's go in a little bit about the research and process behind it. Can you briefly tell us how Drufo was developed?
Yes. I assembled a team of researchers and toxicologists who essentially had the task of diving deeper into the background of the chemical. Carson Durst was a part of that team.
What was your relationship like with Miss Durst?
In the past, I would say Miss Durst and I had a lot more of a significant relationship, but now I would say we don't have one, very much of one at least. And that may help you understand how confusing it is to see her testifying against me, as I essentially used to consider her a daughter.
What was Miss Durst's job while working at Lush?
She was a part of a lot of different projects researching different chemicals. And she started out on the research and development team, and then became a product development engineer.
What projects was she a part of?
Like I said, she was in charge, or was a part of the team researching Drufo, as well as other chemical projects.
Did Miss Durst ever make you aware of any concerns surrounding your products, such as Drufo?
No. And she worked at Lush for 3 years, so over 1,000 days, if I were to ballpark it. And she had every right and opportunity, for that matter, to come to me if she had any concerns, but she didn't.
You said Miss Durst had every right to come and talk to you. Could you expand on this a little bit?
Absolutely. For starters, I make it very known to my employees that my goal with Lush is to create a safe and sustainable product. So if they have anything of concern, they should definitely bring it to me. And additionally, I gave her this job and she had duties to fulfill. And I don't think that she fulfilled those, and she never came to me.
Okay, let's talk now about Drufo and its safety. Have you ever had any reason before to believe your products were dangerous?
No, none of the members of my esteemed toxicology team, including Carson, ever brought any concern to my attention. And in addition, in terms of studies about Drufo as a chemical in total, outside of Lush, I have never seen any valid studies published demonstrating that it's harmful.
Could you please take a look at Exhibit 1, which has been previously admitted into evidence?
Yes, absolutely.
What is the first active ingredient on this label?
Drufo.
Ms. Doncourt, could you please read the first 2 sentences of writing under user safety recommendations?
Yes. As with any spray fertilizer, utilize protective clothing that covers exposed skin. Use of a respirator or N95 face mask is recommended.
What was the purpose of this warning?
To give a strong recommendation of what gear one should wear while handling our products.
You testified a moment ago that you didn't have any concerns surrounding the safety of your products. Yet, Lush included a safety warning on its packaging. Why was this?
Yes, absolutely. It's simply a requirement. It's something you have to do. Think of it like the nutrition facts on the back of a box of crackers. It's just simply something you have to include.
You just said that Drufo is a star component of your fertilizer. Let's return to this. Are you aware that some people are claiming you should have baked Drufo before using it?
Yes, I am aware of that.
And did Lush bake Drufo?
No, it did not.
Your Honor, let the record reflect that I'm asking my opposing counsel and witness to refer to what has been marked as Exhibit 8.
Very well.
Ms. Doncourt, do you recognize this exhibit?
Yes, I do.
What is this exhibit?
This is a 10-year amortization chart from the years of 2004 to 2014.
Who created this document?
I did.
Why did you prepare this?
It's simply a routine practice, as I'm sure lots of other CEOs have to do the same thing. It's a way to analyze your costs every once in a while.
Is this a fair and accurate copy?
Yes, absolutely.
Your Honor, at this time, I move to admit Exhibit 8 into evidence.
Any objection?
Your Honor, as I intend to use this exhibit during my cross-examination, I have no objection.
Very well. Exhibit 8 is admitted.
Thank you, Your Honor. Permission for my co-counsel to publish to the jury.
Yes.
Ms. Doncourt, could you please summarize this report?
Yes. Exhibit 8 essentially shows how we analyze what the cost would be if we were to bake the product.
What did you conclude as far as these costs?
Lots of things, but I mean, in total, we concluded that because there was no verifiable information or awareness regarding significant harm with Drufo, the costs were simply not justified. And let's still be mindful of the fact that I had no knowledge of any significant harm or need for action for Drufo as well.
Thank you, Ms. Kozlowski. Ms. Doncourt, what impacts would baking Drufo have on Lush?
Lots of different things, but I mean, one of the biggest ones would probably be that because it would increase our costs, it would prohibit us from doing things that are so important to our company, like charities, for example.
Ms. Doncourt, why have you not implemented baking into your company?
It simply wasn't justified. I mean, based on 3 years of research, there was never enough risk to justify the amount of time or money or resources that it would take to test something that would simply be unnecessary according to my knowledge of the chemical. I was also never advised to.
You sound pretty certain that Lush did not cause Ms. Weir's cancer. How are you so sure?
Make no mistake, I do feel horrible for the suffering that Mr. Weirs is going through. I personally could never imagine it. However, not only am I aware that my product did not cause this, I'm also aware of the fact that Mr. Weirs worked with a plethora of different fertilizers during his landscaping career. So then I come to the question of why my company is the only one being questioned in this case.
Thank you, Ms. Doncourt. I have no further questions.
Your Honor, I have no objection.
Oops, I'm sorry. I thought I heard something.
I object to Ms. Doncourt's statement that Lush fertilizer did not cause Dakota's cancer, as it is improper lay witness testimony pursuant to Rule 701. This would specifically require medical expertise or expertise in toxicology, which Ms. Doncourt does not have. And as such, this testimony is substantially more prejudicial than probative pursuant to Rule 403, as the probative value of Ms. Doncourt's lay witness belief is substantially outweighed by the risk of unfair prejudice that the jury could take her belief as fact.
Response.
Your Honor, under Rule 701A, this is rationally based on the witness's perception, as she is the CEO and is here to defend her company today based on what she knows about her products.
May I respond, Your Honor?
Of course.
The proper foundation has not been laid to show that Ms. Doncourt has any reason to believe that Drufo does not or did not cause Mr. Weirs' cancer. At no point did Ms. Doncourt testify to conducting any sort of research on the carcinogenic effects of Drufo or evaluating said test results.
I'm going to permit the testimony under 701. I suspect your cross-examination will test her ability to observe, but I'll overrule the objection.
Thank you, Your Honor.
Okay, any cross-examination?
Yes, Your Honor.
Very well. Who is conducting our cross-examination?
That would be me, Your Honor, Hannah Feeney.
Ah, very well. Thank you. Very well, you may proceed.
Ms. Doncourt, first I'd like to talk about something you said on direct examination. You claimed that no one ever brought up any concerns about Drufo causing cancer, correct?
Yes, I did say that.
However, have you ever said that Carson Durst brought up the risks related to Drufo in 2006 when she was fired?
If you're referring to if I testified to that in my direct, no, I did not.
Have you ever stated either in your testimony today or in your affidavit that Carson Durst told you about the risks of Drufo when she was fired?
Carson never came to me, no.
You wrote an affidavit for today's case?
Yes, I did.
You swore to be as complete and accurate as possible?
Yes,
You knew you had the obligation to update this affidavit with any new or relevant information up until the moment of trial?
yes,
I'd like to direct your attention to your affidavit, which should be in front of you. You do have it, correct?
yes, I do.
Please follow along silently as I read aloud from line 63. Carson's claim about Drufo never came up until Carson was fired. Did I read that correctly?
Yes,
And just to clarify, you didn't hear that Carson's claim was that Drufo is carcinogenic, correct?
I'm sorry, could you repeat your question? I'm having a little bit of trouble understanding your question.
Just to clarify, you heard Ms. Durst testify today that she claims that Drufo causes cancer, correct?
I did hear her testify to that, yes.
Now let's talk about some things we can agree about. Lush fertilizer contains Drufo, right?
Yes, that's correct.
Drufo is a binding agent, isn't it?
Yes,
Meaning it glues the fertilizer to what it's sprayed on, right?
yes, I believe that is what binding means.
Anyone can purchase Lush fertilizer, correct?
Yes,
We can agree that if there are any risks associated with Lush fertilizer, there should be a warning label on the packaging, right?
yes,
In fact, if Drufo was found to be carcinogenic, it shouldn't even be on the market, should it?
if it were found to be, yes. I mean, that would be a huge risk. Of course, it would not go on the market if that was the case.
If your company put a dangerous product in the hands of the public, there would probably be a paper trail, wouldn't there?
Yes, I'm sure, as there would be with any dangerous anything going on the market.
So let's talk about that paper trail. If you'd please refer to Exhibit 3, which should be on the stand in front of you. If my trial technician would please display Exhibit 3 on the screen. This is the study that Carson Durst found during her employment at Lush Fertilizer, correct?
Objection, Your Honor. I don't believe that Ms. Doncourt anywhere in her statement brings up Exhibit 3 or has any knowledge of this study.
Bonds?
Yes, Your Honor. If Ms. Doncourt does not have any knowledge of this study, then she may testify as such. However, she was present for the testimony of Carson Durst in today's case, who did testify to Exhibit 3.
Well, I will allow the questioning, so, but be advised that you may renew your objection a little further down the road, but I'll allow the line to go a bit further.
So Ms. Doncourt, this is the study that Carson Durst found during her employment at Lush Fertilizer, correct?
Yes, I believe it is.
While not by name, this study references your company using Drufo in its products, doesn't it?
Yes.
This study found a dose-related increase in lymphomas and leukemias from exposure to Drufo, yes or no?
Yes, I do believe it.
Objection, Your Honor. This line of questioning is asking my witness to extrapolate from their statement.
May I respond?
Go ahead.
Your Honor, this is not unfair extrapolation pursuant to Rule 6.2 of the Rules of Competition, as a witness may testify to any information within their affidavits, exhibits, and other affidavits if they would reasonably know information. Exhibit 3, as such, Ms. Doncourt may testify to what is contained within Exhibit 3. And both of the previous questions were directly from the content of Exhibit 3.
Well, let me just say this, an unfair extrapolation objection can only be made on direct, not on cross. So you can certainly ask, and the panel will decide whether or not this is good questioning. So I'll overrule. I guess I can't even rule on unfair extrapolation. So let's just proceed.
Yes, Your Honor. So, Ms. Doncourt, you are aware that this study found a dose-related increase in lymphomas and leukemias from exposure to Drufo, right?
Yes.
Thank you. Exhibit 3 is no longer needed. Let's talk about baking your fertilizer. Baking your fertilizer would have removed any risk that it could cause cancer, correct?
Yes, the very little, but yes.
So, but you chose not to bake your fertilizer, isn't that right?
It was an informed decision that I made based on the well-being of my company and the knowledge that I had of the chemical.
You made your decision to not bake it because it would have been too expensive, right?
More so, I would look at what those costs would hinder, things like charities.
However, the cost of baking your product was a reason why you chose not to bake Drufo, correct?
Based on what it would prohibit, yes.
If you would look at Exhibit 8, which should be in front of you, if my trial technician would please display that exhibit on the screen. This is the amortization table you made, correct?
Yes, it is.
In 2004, it would have cost $250,000 to bake Drufo, right?
Yes.
In 2004 alone, you made $1,675,000, correct?
Yes, that's correct.
With an increase in profit by 2% each year?
Yep, every following year.
Thank you, Your Honor. I have no further questions. However, I do ask the court to take judiciary notice pursuant to Rule 201 that the total profit from 2004 to 2014 is $18,994,341. This number is the result of adding all numbers in the column titled Profit Before Baking.
I'm not sure that is something that we need to take judicial notice of. I think you can reserve that for the argument to the jury at the end. So it's not a fact outside the evidence that I need to take notice of. So I'm not going to do that. But do we have any redirect on behalf of the defendant?
Yes, Your Honor.
Very well.
May I proceed?
Hold on. Thank you for asking. Yes, you may now proceed.
Ms. Doncourt, although Ms. Durst may have come to you after her employment, during her employment, did she ever bring you any concerns about Drufo?
No, and I'd like to make it very clear that that was the time in which I was in charge of her employment. Therefore, it would have been my concern had she brought it to me, but she did not.
And how long did Ms. Durst work for Lush?
Like I said, 3 years. I believe I even said over 1,000 days if I were to ballpark it. That's a pretty long time not to bring concern if you have it.
And had Drufo been found to be carcinogenic as a definite or just as a possibility?
Just as a possibility.
Thank you. I have no further questions.
Very well. You may step down. Is there another witness?
Yes, Your Honor. The defense calls Miss Skylar Weirs to the stand.
Very well, Skylar Weirs. You are still under oath. And who will be conducting the examination?
I will, Your Honor. Kendall Kozlowski.
There we go, Ms. Kozlowski. Very well, and you may proceed.
Good afternoon, Ms. Weirs. Can you please state your full name and spell your last for the record?
Good afternoon. I'm Skylar Weirs. It is Weirs.
And Ms. Weirs, what's your relationship to the plaintiff?
I'm Dakota's loving sister.
And what do you do for work?
I am a prominent investigative journalist.
What do you do as an investigative journalist?
Well, I work mostly unveiling the conflict between corporate policy and individual health, which includes several areas of expertise in order to develop scientifically accurate studies.
And what publication do you write for?
The Rationalist.
For those of us who aren't familiar with this publication, can you tell the jury what The Rationalist is?
Of course. Well, I guess I could say The Rationalist is a quarterly science education and science advocacy magazine, published by the Rationalist Society, a nonprofit organization devoted to resisting the spread of pseudoscience, superstition, and irrational beliefs.
And what area has your work specifically focused on?
Agritech mainly, which is an industry that has been attacked by pseudoscience. I know I don't have a college degree, but my knowledge base involves general knowledge plus historical and statistical information, and you don't need a degree for that. In fact, outside of the USDA and the NASDA, I doubt anyone has the overall perspective on modern agritech that I do.
Ms. Weirs, you're talking about agritech. Can you explain to us what agritech is?
Yeah, oh, sorry. Sometimes I forget that everyone doesn't already know, but agritech is simply as it sounds, technology that is developed to improve efficiency and or yield of agriculture.
And what research have you done specifically on agritech?
Well, I've spent a considerable amount of time researching agritech companies by reviewing publications written by those companies, researching studies, and looking at information maintained by, as I mentioned, the USDA and the NASDA. In fact, recently I have written an entire series on modern agritech.
And you said a considerable amount of time. How much time was that?
I spent a full year reading and researching from scholarly sources.
And then in addition to agritech, are there any other topics that you have researched?
Yeah, I have also researched the conflict between individual health and corporate policy.
Your Honor, at this time, we move to have Skylar Weirs admitted as an expert in the field of agritech under Rule 702.
Any objection?
Yes, Your Honor. My objection is based on the same grounds that I made during my pretrial motion that was ruled upon, that being that simply Googling things for a year does not qualify somebody as an expert. And therefore, Skylar Weirs lacks the necessary training, expertise, or knowledge to render opinions as an expert under Rule 7.
Right. Any response?
Yes, Your Honor. In the pretrial ruling, you ruled that this witness could properly testify concerning Agritech if the proper foundation to give expert opinions was established. We've established that foundation by showing that Ms. Weir spent considerable time researching Agritech companies and reviewing publications written by those companies, research study referenced in those publications, and information maintained by the USDA and the NASDA. Accordingly, we believe that we have met the requirements of your order and therefore believe that this witness should be allowed to testify as an expert witness in the field of Agritech.
Very well. I have reviewed, it was actually Judge Staub's order, but I have reviewed the order once again in preparation for today. The rule permitting testimony by experts does not require certain levels of training and expertise, only that which is superior to that of the average juror. And I think this witness has met those particular requirements again by the testimony. So I am going to overrule the objection. I will permit the person to be qualified as an expert in Agritech, Skylar Wires as an expert in Agritech, subject to cross-examination.
Yes,
Thank you, Your Honor. Ms. Weirs, I'd like to return to talking about pseudoscience. What is pseudoscience?
Well, basically, it's a collection of beliefs or practices, you could say, mistakenly being regarded as science when it's actually false.
And how does pseudoscience relate to lush fertilizer?
Well, the so-called old guard of the agritech sector is spending billions of dollars to destroy the reputation of lush fertilizer because Lush's patent breakthrough Drufo threatens to upend their entire business.
And is this practice of undermining companies and their scientific basis new?
As crazy as it might sound, these bought and paid for pseudoscientific hit jobs are nothing new in the world of agritech.
And can you give us an example of a hit job that you've seen?
Yeah, well, Monsanto, for example, as I'm sure you've heard of, was a revolutionary agrochemical company that was so good it was on the verge of monopolizing the corn industry when its competitors effectively launched an aggressive PR campaign to disrupt the genetically modified crop from the market. But hundreds of studies have shown that they are safe and even have the potential to help end world hunger.
And in your research, did you find any similarities between this and the campaign against Drufo?
Drufo works a miracle in the herbicide industry, and its revolutionary technology scares competitors, and it gives them a motive to start a pseudoscientific attack, similar to those against Monsanto.
And based on your research, how does misinformation like this affect agritech products and the companies?
Well, I've seen the same pattern repeat itself as advanced technology reaches the market and often has the potential to seize the industry. It suddenly is attacked, whether for safety or lack of research. These products are often good and don't reach their capability because of these attacks.
And how do these misinformation campaigns, like you were just talking about, specifically affect Drufo, which is the chemical used by Lush fertilizer?
Well, before Dakota got sick, I published an article based on my agritech research, formulated from research I reviewed, about the false myth that there's a connection between Drufo and cancer. Therefore, I stand for the science when I say that it is a misinformation campaign trying to take down Drufo.
And can you tell us about some of the potentially harmful effects of agritech in general?
Yeah, well, to be frank, all fertilizers and pesticides are poisonous to some degree, as their job is literally to kill undesirable organisms. But based on my research of these agritech products, Drufo is by far the safest of the industry line. Lush has created a product with far less nitrogen than its competitors.
And along with these environmental benefits, are there financial benefits to using these new kinds of agritech?
Yeah, well, Drufo, for example, only needs to be applied once or twice a year. So you don't need to buy as much product. Other grass fertilizer needs to be applied 5 or even 6 times per year to achieve the same nitrogen penetration. Because Drufo reduces the solubility of lush fertilizer, the nitrogen in this product is also less likely to contaminate groundwater and waterways.
I want to turn now to talk about your relationship with Dakota. You told us a few minutes ago that you and Dakota are twins. Could you tell us about your health today?
Yeah, I'm in spectacular health.
And could you tell us about how your different lifestyles could have contributed to this difference in your health?
Yeah, well, based on my agritech research, it really wouldn't surprise me if Dakota developed non-Hodgkin's lymphoma based on past exposure to a whole host of products that contain carcinogens from Dakota's work in landscaping. But Dakota is blaming the one product that was designed to reduce the need for continued and repeated exposure to harmful chemicals. If Haven Landscaping didn't use lush fertilizer, Dakota might have been exposed to synthetic nitrogen far more often.
And finally,
Okay, I hear an objection, please.
Your Honor, this is outside of the scope of this witness's expertise under Rule 702, as the witness was specifically qualified as an expert in agritech and only agritech. The witness does not testify to having any medical or toxicology background that would allow them to opine on anything regarding the toxicity or possible effects of that toxicity of various chemicals. Therefore, this is more prejudicial than probative, as there is no probative value, and this simply goes to prejudice the jury.
Response.
yes, Your Honor. Your Honor, she's not testifying as an expert in cancer or Drufo. She's just offering an expert opinion based on her review of many studies in the field of agritech.
One more response.
Your Honor, the witness was specifically referencing how Dakota Weir's condition might be different had Mr. Weir's done something different. That is going directly to Mr. Weir's medical diagnosis and possible effects of different fertilizer products, and therefore is outside of the scope of this witness's expertise as pursuant to Rule 702.
Yeah, I agree with you. I think it doesn't even fall under 701. So I'm going to sustain the objection.
Your Honor, I move to strike the entire last answer from the record.
And it will be stricken.
Thank you, Your Honor. Permission to proceed.
Yes, please.
Finally, Ms. Weirs, why are you testifying here today on behalf of the defendant against your twin?
Well, it's not easy, but my motto in life is science over speculation. I have devoted my entire career to science, and I can't go against what I know is right.
Thank you, Ms. Weirs. No further questions, Your Honor, and I pass this witness for cross-examination.
Hey, cross-examination.
Yes.
I'll let you know when to go.
Your Honor, this is Melissa Nicoletti. If I can ask Team Stanley to please turn on their witness camera, because the witness camera is connected to the microphone, we can't see you on the full screen. So if you can turn on the witness camera again and then stand in front of the witness camera so we can see you on the full screen as you're speaking and asking questions.
Yes, Your Honor, if you would give us just one moment to do that.
Absolutely.
And don't run any
sorry.
time until that's happened.
Yeah, I'm sorry.
No, don't be sorry. Let's think you got a point. I was noticing that too.
Perfect. I can see you.
Okay, that looks better. Thank you. All right, and now you may proceed.
Ms. Weirs, we can agree that pesticides are by definition poisons, right?
To some degree, all pesticides are.
Have you ever said pesticides are by definition poisons?
Yes, to some degree.
And virtually every pesticide on the market contains well-known carcinogens. Am I correct?
Yes.
And Drufo is not only a fertilizer, but it's also an effective pesticide, isn't it?
It is.
I want to talk a little bit about some problems that you've had with honesty. You had to gamble, you lied about your age to gamble in high school, didn't you?
Objection, Your Honor. Under Rule 403, this is more prejudicial than probative.
Response?
Your Honor, this is proper cross-examination as to the quality and credibility of this witness, as the witness lying about their age or any facts about their life goes directly to the credibility of this witness, and it is proper cross-examination.
Response?
Your Honor, I stand with my objection. This does not go to the credibility of the witness.
I think it probably could be relevant to the credibility, and that's fair game. So I'm going to overrule the objection. You may proceed.
So Ms. Weirs, you had to lie about your age to gamble in high school.
This is not in my statement. Would you like me to answer anyway?
You mentioned that you were gambling, correct?
Correct. It was the March Madness about this time a few years ago.
And that was before you turned 18, wasn't it?
A few years ago, yeah.
Meaning you are aware that the legal age to gamble in the United States at a minimum is 18, right?
That is not in my statement.
But you are not aware of the laws surrounding activities that you were partaking in?
Would you like to go outside of my statement?
Just a yes or a no to my question. You weren't aware of that, or you were aware of that, right?
Well, I believe the March Madness that you were referring to was actually a few years ago. I am 20 now, so a few years ago, I could have been 18.
And you were gambling before then, weren't you?
I feel like we're just going back and forth here, but it was a March Madness a few years ago, yes.
And you got into quite a bit of debt from that, didn't you?
I did. I went into a little bit of a hole.
And you still haven't been able to crawl out of that hole, have you?
Objection, Your Honor. Relevance.
Response?
Your Honor, this is going to the quality and credibility of this witness, and therefore is proper cross-examination, as this goes to possible financial motives that the witness might have, as well as ties into their abilities as a journalist.
Do you have some questions that's going to establish that this witness is going to gain financially from her testimony?
Your Honor, my next line of questioning goes to the fact that the witness has not made a very lucrative career because they're not a particularly good journalist.
And in what way is her testimony today going to enhance her financial bottom line?
I don't have anything about that, Your Honor.
Very well. I'm going to sustain the objection. We're going to deny that level of questioning. You may proceed.
Thank you, Your Honor.
You cannot currently make ends meet, can you?
Well, I actually had to get a part-time job at Applebee's to make ends meet, so I am right now.
But you're not able to do it with only your journalism career, right?
No, it's not a super lucrative career, but it's something that I believe in and I'm really interested in, so I love doing it.
I want to talk a little bit about your qualifications. You have no degree, do you?
Sorry, what was that?
You have no college education, do you?
No, I chose to forego college. It just didn't seem necessary for my path.
And like you testified, you currently work for a magazine called The Rationalist, don't you?
I do.
And like you said, The Rationalist tries to resist the spread of pseudoscience. Am I correct?
Correct.
And it's your opinion that lush fertilizer is somehow a victim of this pseudoscience. Am I correct?
Correct. It's a pattern in the old guard of the agri-tech sector that often really good products are taken off of the market because of this.
That's a yes to my question.
Yes.
In fact, you would go as far as to describe the allegations against lush fertilizer as mass hysteria, wouldn't you?
Yeah.
So I want to talk a little bit about what your research found. You, in your own opinion, the research on whether Drufo causes cancer is inconclusive. Am I correct?
Correct. I'm not aware of any study that has found Drufo causes cancer with any level of certainty.
Meaning you can't definitively say that it doesn't cause cancer because it's inconclusive, right?
Right, but you also can't say that it does cause cancer.
So nitrogen is known to cause a myriad of health effects, right?
I believe so.
In fact, it's even known to cause cancer, isn't it?
Yes.
Now I'd like to direct your attention to Lush fertilizer packaging, exhibit 1, which should be in front of you, specifically the second active ingredient. Ingredient is nitrogen, isn't it?
Let me just find the exhibit, please. Yes.
And Drufo works kind of as a bonding agent, right?
That's right.
Meaning it essentially glues the fertilizer to whatever it's sprayed on, right?
It glues the fertilizer, whatever it's sprayed on. Is that what you said? Sorry.
Yes or no, it glues the fertilizer to what it's sprayed on.
Yes.
And it can't easily be washed off once it's glued there, can it?
I don't believe I testify to that, but as I've never worked in landscaping myself, but I would assume as it's a bonding agent.
Oh, well, Lush fertilizer or the Drufo in Lush fertilizer means that it's not very soluble in water, right?
Correct.
And it doesn't get washed away very easily, does it?
No.
Finally, I want to talk about where we can maybe agree. Lush fertilizer isn't safe, is it?
Well, it's safer than the rest of the industry line. It's the safest one out there. And so if you're going to be using pesticides and fertilizer, Lush is the best.
So yes or no, Lush fertilizer isn't safe, is it?
It's not completely safe, but it's much safer than other pesticides.
Thank you. Your Honor, no further questions at this time.
Very well. Any redirect?
Yes, Your Honor, just briefly. Let me know when I should proceed. Ms. Weirs, just to summarize, in your review of research on agritech, have you found any reliable scientific research indicating a link between Drufo and cancer?
No, I'm not aware of a single study that has established a link between Drufo and cancer with any level of certainty. In any event, Lush Fertilizer's development of Drufo actually protected consumers by eliminating exposure to carcinogens.
Thank you, Ms. Weirs. I have no further questions.
Well, any other witnesses?
Yes, Your Honor. The defense calls Dr. Devin Williams to the stand.
Dr. Devin Williams. You remain under oath. Let's see who's going to be, Giselle is going to be questioning. Very well, and you may proceed.
Thank you, Your Honor. Hello, Dr. Williams. Could you please introduce yourself to the jury?
Good afternoon. My name is Dr. Devin Williams, Williams.
Dr. Williams, where are you currently employed?
I work at Lush. I'm also an assistant teacher at University of New Mexico College of Pharmacology, and I've previously worked as a chief medical examiner toxologist.
What is your role with Lush?
I initially started as a technician working with Drufo development, then was promoted to lead toxicology research and development labs at Lush Fertilizer, and I'm the outgoing chair of the company's ethics committee.
How long have you worked for Lush?
I started my career with Lush roughly a decade ago and have led the toxicology labs for 7 years now.
Let's go into your qualifications to hold this job. What degrees have you earned?
I have a Bachelor of Science degree in pharmacotoxicology and a Master in Science of Forensic Toxicology specialization, along with a PhD in pharmacology and toxicology.
Do you hold any other certifications?
Yes, a Colorado Department of Public Health and Environment Laboratory Director Certificate of Qualification, focusing on forensic and clinical toxicology.
Finally, how do you utilize your training and experience while working for Lush?
I research and evaluate tests to determine if the substance is going to harm the average human and how to neutralize that harm if it happens.
Your Honor, I move to admit Dr. Devin Williams as an expert witness in pharmacology as well as clinical and forensic toxicology under Rule 702.
Okay, pharmacology as well as clinical and what?
Forensic toxicology.
All right, any objection or voir dire?
Honor, a brief voir dire.
Very well.
Now, Dr. Williams, you don't have a degree in any medical field, do you?
No, I'm not a medical doctor.
And with that, Your Honor, due to your previous ruling regarding Dr. Rogers' qualifications to become an expert in toxicology, I bring up the same point that Dr. Williams, as they don't have a medical degree, that they do not, they cannot be qualified in toxicology.
Response.
Yes, Your Honor. Something different about my witness is they worked for the chief medical examiner. They worked as the chief medical examiner toxicologist for several years, giving them the experience they need to testify in toxicology. Therefore, they should be able to be qualified in this field because pursuant to Rule 702, a witness needs either knowledge, skill, experience, training, or education. And with toxicology, my witness has showcased much training, education, experience, knowledge, and skill.
All right, being employed by the medical examiner can take many forms. You can be the secretary, or you could be the janitor, or you could do something more substantial. Please ask a few questions regarding the level of duties that this expert basically undertook at that office.
Yes, Your Honor. Dr. Williams, for your job as the chief medical examiner toxicologist, what exactly did you do?
I research and evaluate tests, and I help determine if a substance is going to harm the average human.
And during your work, did you perform methods of forensic toxicological analysis of human samples during your work at autopsies?
Yes.
And was this used to determine the role of drugs, or was it not in their death?
It was used.
Thank you. Your Honor, I now moved to admit my witness and an expert in pharmacology as well as clinical and forensic toxicology under Rule 702.
Any further objection after that bit of additional questioning?
Yes, Your Honor. This Dr. Williams still does not have a medical degree specifically, so they cannot testify as a toxicologist. As you previously ruled, similarly relating to Dr. Rogers, they don't have a degree.
Well, I'm going to permit the qualification of this witness based upon the significant difference. And the difference that I see here is that actually doing work in the forensic toxicology field in a basically a job that requires that you do that kind of work confers a different type of level of expertise. Certainly doesn't rise to the level of a medical doctor, but I think I'll allow it. So I'm going to qualify. I'm going to overrule the objection. I'm going to allow the qualification as in pharmacology as well as clinical and forensic toxicology. And you may continue.
Thank you, Your Honor. Dr. Williams, what are you here to testify to?
I'm here to testify based off my education and experience that Drufo does not increase one's chance to get non-Hodgkin's lymphoma compared to other fertilizers.
Could you elaborate on this?
Drufo has not been correlated with a statistically significant increase in the incidence of non-Hodgkin lymphoma or any other cancer.
What statistics are you referring to?
The data I analyzed while working for Lush.
And what did this data show you?
All of the data we looked at showed that users of fertilizers with Drufo did not have an elevated risk of non-Hodgkin's lymphoma compared to users of other fertilizers.
How did you come to this conclusion?
When we analyzed the data for Drufo fertilizer, there was no statistically significant increase in developing non-Hodgkin's lymphoma with the use of Drufo than there was without it.
Can people not exposed to chemicals develop non-Hodgkin's lymphoma?
Yes, unfortunately, no matter the circumstances, in a group of people, some will develop non-Hodgkin's lymphoma and then some will not.
And what kind of people did the data look at?
We looked at users of Drufo fertilizers and users of fertilizer without Drufo and found no notable difference in the number that developed non-Hodgkin's lymphoma.
And why was that significant?
Because it's demonstrated that the use of Drufo has no correlation to an increase in developing non-Hodgkin lymphoma.
I would like to turn our attention to a study done by Dr. Rogers about the carcinogenic effects of Drufo. Are you familiar with this study?
Yes.
What is your professional assessment of the study?
The study is flawed, as it basically compared apples to oranges and made a statement based on its results.
What do you mean by apples and oranges?
Rogers looked at exposure to Drufo for farm laborers versus casual gardeners versus people who didn't do either of those things and compared rates of non-Hodgkin's lymphoma.
And why is this important?
Because Drufo isn't the only difference between the groups of people he looked at. They have different lifestyles and are exposed to different products and environmental conditions, such as pesticides and herbicides.
Why do these different environmental exposures matter?
It is possible that farm laborers and gardeners in general have a higher incidence of non-Hodgkin's lymphoma. Simply, this has nothing to do with Drufo, but everything to do with other environmental exposures.
What would have been a valid form of this study?
A valid study would have needed to compare something like farm laborers who use Drufo fertilizer to farm laborers who use fertilizers without Drufo.
Was there anything else wrong with the study?
It has not been peer-reviewed or replicated. Without being replicated, we cannot draw reliable conclusions from this data, especially due to the fundamental flaws.
Finally, in your expert opinion, do you believe Drufo causes cancer?
No, it does not. And I do not believe there is any valid evidence to support the plaintiff's claim that it does.
Dr. Williams, thank you for your testimony. Your Honor, I have no further questions.
Well, cross-examination.
Yes, Your Honor.
Dr. Williams, may I proceed, Your Honor?
Yes, give me a second. All right, you may proceed.
Dr. Williams, you've only been working in the agriculture industry for about a decade, isn't that right?
Yes.
And when Lush Fertilizer hired you, it was your first job in the industry, wasn't it?
Yes.
And in Lush Fertilizer's first few years, they had a hard time keeping on employees, didn't they?
Objection. Opposing counsel's question is calling for my witness to answer in speculation.
Response?
Your Honor, this question does not call for speculation as the answer is directly from the affidavit.
Well, if you can establish that she has a basis of knowledge for this, then I'll allow it. I'm going to overrule the objection, but you need to establish that basis.
Dr. Williams, when you joined Lush Fertilizer, half of the Drufo development team had moved on to outside ventures. Isn't that right?
Yes.
And Lush Fertilizer promoted you to lead the toxicology labs after only 3 years of experience working in the fields, correct?
Yes, I was promoted based off my education and experience and my training.
And as the leader of the toxicology labs, your primary focus is not on the safety of the product, is it?
I disagree. I focused on finding any harm if in any substance and focused on neutralizing that harm if there was any.
Well, that's a pretty important fact in today's case. Wouldn't you agree?
Yes.
And despite that, you never mention that in your affidavit, do you?
I mentioned that I do try to find any harm in a substance and I neutralize that harm if there is.
But in your affidavit, you say that your primary focus is to oversee work on environmental impacts. Isn't that right?
That's my primary focus, but I'm also able to focus on other things such as the health.
And protecting people from cancer is never a primary focus of your job, is it?
It is a focus of my job, but not my primary.
And you never mention protecting people from cancer being a focus of your job in your affidavit, do you?
As I said before, part of my job is to find any harm in a substance and to determine if there's any harm and how to neutralize that harm if it happens.
But protecting people from cancer is not in your affidavit, is it?
No, but it is my expert opinion that Drufo does not cause cancer.
Now, I want the jury to understand exactly what the problem is with nitrates and what Drufo does to solve that, at least environmentally. Now, we can agree that Drufo is a potentially toxic chemical agent, can't we?
Yes.
And that's because it contains nitrogen as well as other chemicals and compounds, right?
Yes.
And in other companies' fertilizer, the excess nitrogen interacts with bacteria around it, creating nitrates, right?
Yes.
Now, comparing that to Lush fertilizer, Lush is sprayed in the air towards the plant by the customer, isn't it?
Correct.
And when your fertilizer is sprayed, it sticks to the things it touches because of the Drufo, right?
Yes, because it's a bonding agent.
So what Drufo does is it acts like glue for whatever Drufo is sprayed on. Isn't that right?
Drufo does stick to what it's sprayed on.
And you have not produced a study of the prolonged exposure of nitrogen that has been essentially glued to somebody's body when they've sprayed your product, have you?
Well, personally, my job isn't to perform any studies. It is to evaluate the studies and come to expert opinions based off of the studies. So no, I didn't.
Oh, that was a no to my question. You have not produced a study, have you?
I didn't because it's not my job.
And I want the jury, and if you take a group of people who have used Drufo products, some of them will develop non-Hodgkin's lymphoma. Isn't that right?
Unfortunately, if you take actually any group of people, some will unfortunately develop non-Hodgkin's lymphoma, but it is my expert opinion that this is not caused by Drufo.
Yes, but if you take a group of people who have specifically used Drufo products, some of them will develop non-Hodgkin's lymphoma, right?
Yes, but in my opinion, not because of the Drufo.
That was a yes to my question?
Yes.
One of the problems you have with Dr. Rogers' study is that it compares those who use Lush at different rates. Isn't that right?
Exactly.
You think that there are other reasons for Dr. Rogers' conclusions, right?
Yes.
And you do not have concern when people who use Lush fertilizer have the same rates of non-Hodgkin's lymphoma as those who use other fertilizers, right?
Sorry, can you repeat your question?
You do not have concern when those who use Lush fertilizer have the same rates of non-Hodgkin's lymphoma as those who use other fertilizers. Isn't that right?
I'm sorry, I'm a bit confused by your question. Can you rephrase it?
So you do not have concern when the rates of non-Hodgkin's lymphoma with those who use Lush fertilizer is the same as those who use other fertilizers, right?
No.
So you do not have concern when someone who uses Lush is 10 times more likely to develop non-Hodgkin's lymphoma than if they had never used a fertilizer at all.
I disagree with that statement.
No. Your research related to Drufo has all been within the company and has not been published. Am I right?
Correct.
And the jury doesn't get to review any of that research, do they?
No.
Thank you. Your Honor, I have no further questions.
Very well. And redirect.
Yes, Your Honor. Dr. Rogers, where did you work before you worked at Lush?
I was a medical examiner for 2 years. And, oh, sorry. I was an assistant professor of toxicology and pathology for 8 years, and I've been a visiting professor in toxicology since 2003.
So was Lush your first job?
No.
And how is nitrogen in Drufo different?
Because less Drufo needs to be sprayed, so there's less nitrogen involved. This is why it's the best.
And finally, do you believe that Drufo causes non-Hodgkin's lymphoma?
No, and I do not believe there's any valid evidence to prove that it does.
Thank you. No further questions, Your Honor. The defense rests.
Very well. So there are no further witnesses on behalf of the defense. Are we prepared to make our final arguments? Or are there any motions before we have our arguments?
No, Your Honor, not from the defense.
Anything?
No non-evidentiary or dispositive motions may be made pursuant to the rules of competition. I have no motions at this time.
Okay, I just have to ask. Okay. Very well. Then let's move into final argument. Who will be arguing for the plaintiff?
That will be me, Your Honor, Hannah Feeney.
Okay. Go ahead and take your position. I'll let you know when to begin.
Your Honor, before I begin, given that the jury instructions have already been provided to the jury, may my trial technician have permission to display them on the screen during the course of my closing argument?
Oh, sure. Yeah. And they, for the purposes of the panel, they appear early on in the case materials. I believe beginning at, there we go, page 6 of the case problem.
I would also like to remind the court at this time that any remaining time has been reserved for rebuttal.
I was aware of that.
May it please the court? Profit over people. Today, you heard how Lush Fertilizer used Drufo in a revolutionary way that essentially glues a carcinogen to someone's skin. You heard how someone who uses Lush Fertilizer regularly is 10 times more likely to develop non-Hodgkin's lymphoma, an environmental cancer. And you heard how Lush prioritized profit over people, ruining the life of 20-year-old Dakota Weirs. The court just read you the jury instructions, so let's review them. First, instruction number 1 tells you that both sides had to prove their claims by a preponderance of the evidence, which is simply a legal term for more likely than not. Think about it like the scales of justice. If the evidence leans even slightly more to our side, you must find in our favor. Next, jury instruction number 2 tells you what exactly we as plaintiff had to prove. We had to prove that Lush Fertilizer Incorporated's negligence caused Dakota Weirs' non-economic damages. We've met our burden. First, we proved that Lush Fertilizer contains Drufo, as it says right here. Second, we proved that Lush did not exercise reasonable care to prevent their product from causing cancer. You heard of multiple independent studies that found Drufo to be carcinogenic, but that Lush chose not to eliminate the risk that their product could cause cancer because they wanted to donate to charity. They only chose to put warning labels on their product which, as you heard from Dr. Rogers, we don't even know would protect their customers from cancer. And third, we proved that Dakota is someone the defense should have reasonably expected to use their product as the legal employee of a landscaping business. Fourth, by using Lush fertilizer in the same way as the other people in the industry, Dakota was diagnosed with non-Hodgkin's lymphoma. You heard today from Dr. Rogers that Drufo caused Mr. Weirs' cancer. We know that Drufo is carcinogenic, but Lush Fertilizer Incorporated's willful ignorance caused significant non-economic damages. That's why I come before you asking for the maximum amount of non-economic damages, $500,000. That amount is justified because using Lush fertilizer destroyed Mr. Weirs' quality of life, his independence. Even testifying has been a major inconvenience because of the physical pain he's in. He can't even play piano. His passion, his future. The emotional distress and trauma this has caused him is immeasurable. Remember, not only should Lush have known their product caused cancer, they did know. They knew their own scientists brought up concerns. Their own internal study recommended baking Drufo to eliminate the risk that it could cause cancer. But they chose to ignore the risks, the concerns, and the recommendations because doing otherwise would have been too expensive. Because Lush chose to prioritize profit over people. Now it's time to hold them accountable. Thank you.
Very well. Can we have a time hack on what time is remaining so the other person can prepare?
There is 1 minute remaining, Your Honor.
1 minute, Ms. Feeney. All right. Argument on behalf of the defendant.
Yes, Your Honor. Permission to proceed?
Yes, you may proceed.
Ladies and gentlemen of the jury, the plaintiff just tried to tell you this case is about profits over people. Now that you've heard all the evidence, Lush Fertilizer asks you to disregard emotional pleas, speculation, and instead focus on the science. The science simply does not link Lush Fertilizer to the plaintiff's cancer. And while it is tempting to want to blame someone for Dakota's illness, the blame should not fall at the feet of Lush Fertilizer. The plaintiff has the burden of proving negligence in this case. That means the plaintiff needs to prove that it is more likely than not that Lush was negligent. In order to prevail on their claim of negligence, the plaintiff has to prove all 4 elements in jury instruction 2, which has already been read to the jury, by a preponderance of the evidence. However, the plaintiff today hasn't proved at least 2 of them. The first element the plaintiff failed to prove is that for the defendant Lush Fertilizer to be found liable, the plaintiff needs to prove that Lush was negligent in not taking reasonable safety measures. The plaintiff tried to tell you that the CEO of Lush, Ms. Doncourt, was negligent. She wasn't negligent because she was never presented with any reliable, conclusive evidence that there was any risk to her customers that needed to be mitigated through baking. The second element the plaintiff failed to prove is that the plaintiff had damages that were caused by the defendant's negligence, while the fertilizer was being used in a manner Lush should have reasonably have expected. You heard yourself that Lush had warning labels that the plaintiff chose not to follow. Lush Fertilizer had a burden of proof today too, and unlike the plaintiff, Lush met its burden of proof. Even if all of the science is disregarded in this case and you, ladies and gentlemen of the jury, find the defendant negligent, you as jurors must also take into consideration that even if the product was dangerous, Dakota's own conduct contributed to his injuries. This is the affirmative defense of comparative negligence. While Lush is sympathetic towards the plaintiff's condition, you heard Dakota Weirs testify that there was a warning label on the package, and he admitted that he didn't follow it. You heard he was advised to wear protective clothing, and he didn't do that either. The plaintiff has cancer, and the natural instinct is to want to blame someone. But based on the scientific evidence presented here today, Lush Fertilizer should not take the blame. Blake Doncourt, the CEO of Lush, wasn't reckless, as the plaintiff tried to tell you. She told you she was never presented with any reason to think that her product could be harmful. Skylar Weirs testified about the misinformation campaign surrounding revolutionary agritech products such as Drufo. And finally, Dr. Williams told you herself that Drufo is not correlated with any serious health conditions. Weighted against all that science is the lack of science the plaintiff presented to you. Their expert witness, Dr. Rogers, testified that they only studied one fertilizer, ignoring any other toxins that the people who they studied were also in contact with, meaning that there is no possible way any increase in serious conditions in the people they studied could solely be attributed to Drufo. You also heard from former Lush employee Carson Durst, who admitted that she works for a competitor of Lush and never brought any concerns about Lush Fertilizer to Ms. Doncourt during her time there as an employee. As she works for a competitor, she violated a confidentiality agreement that she had with Lush not to share trade secrets. She wants you to believe her word today, but she doesn't even keep her own word. Finally, the plaintiff is angry. They want to blame someone for their illness, but as they testified to you here today, they simply didn't follow the proper safety precautions that they were supposed to while using any fertilizer. And as a result, they don't know with 100% certainty what caused their cancer. Ladies and gentlemen, Lush Fertilizer is not at fault here. The plaintiff has failed to meet their burden by a preponderance of the evidence. Based on the scientific evidence we showed here today, as well as a lack of evidence by the plaintiff, we ask that you not allow your sympathy for Mr. Weirs to influence your decision. We ask that you base your decision on science and find the plaintiff failed to meet their burden in proving Lush Fertilizer was negligent. Thank you.
Very well. And rebuttal argument.
Yes, Your Honor. Before I begin, may I confirm how much time I have remaining?
I think I heard a minute.
Yes, Your Honor. You have 1 minute remaining.
May I please the court? Let's look at the science. Let's look at the multiple studies that found that Drufo causes cancer. Let's look at the fact that most people in the agriculture business don't wear or can't wear protective gear. And that even if they did, we don't know that it would work. Let's look at the fact that Carson Durst tried her best to report her concerns to Lush Fertilizer, but she was silenced because Lush chose to prioritize profit over people. Find Lush Fertilizer Incorporated solely negligent and award Dakota Weirs $500,000 in damages. Thank you.
Very well. Thank you very much. Wonderfully done. While the scoring panelists, and we're running long here, but as the scoring panelists are finishing up their numbers and submitting, and do remember to press submit on the scoring sheets. I will offer a few preliminary bits of information. First of all, you all did excellent work. There's no question as to why you are at this level. You've all done amazing work. Please, I urge you to continue, if you wish, into the legal profession. You will all do very, very well. A few very, very quick comments. The storytelling I thought was excellent. The objections I thought were well done and pointed on each side. One of the things that Ms. Gisele did on the cross of Dr. Rogers, I believe it was. Well, first of all of you seem to do this a bit. You seem to want to add correct or right or whatever at the end. You don't need to do that. Just allow the thing to sit and let them answer. The fact that you said you did not provide us that report, then you could have followed it up. It was so easy. Do you agree this is a serious matter? This jury needs to take it seriously. And you should too, shouldn't you? So you should provide this, shouldn't you? So that they can do their jobs. But what you're doing right now is you're just saying, well, I'll take my word for it. I'm a really smart person. You don't have to be sure because I'm telling you what to believe. See, that's kind of a cute little thing that you could have done, that each of you can do. Very, very quickly. Oh, good looping, good transitions, excellent work. Your coaches did an amazing job with you, each of you. On Kozlowski, on Skylar Weirs, there was I believe Mr. Winton had a good objection and a good motion to strike, but do one more thing. Say, I would ask that the jury be instructed to disregard that testimony. And of course, I would make that instruction, but then take one more step. Say, Your Honor, I don't believe that we can unring the bell. I move for a mistrial. And then that's when the judge will say, no mistrial. Then you've got your point for appeal. But before you get to that point, you don't have a good appellate issue. Slippery witnesses. Each of you had to deal with slippery witnesses on cross-examination. One thing to consider, slippery witnesses can be brought under your thumb by saying, you can interrupt them actually and say, I'm sorry, I don't think you understood my question. Let me try again and ask the question again. And if they wander off into a narrative, say, boy, I did it again. Let me try one more time and ask the question again. And what you've done is that you focus everybody's attention on the fact that they're turning this thing into some sort of a narrative. And if they still do it, then you can say, well, I think it's clear to everybody in the courtroom, you really, really, really want your side to win. But I'm entitled to get answers to my questions. Can we just do that? Can we agree to that? And it doesn't matter what they answer. You've already killed the witness. Anyway, couple of fun pointers on that. I want the scoring panelists to have a few minutes as well. So and since I can't see you in the room, which I normally love to do, I'm just going to have to ask you guys to speak up.
We can put so scoring panelists, please turn on your cameras.
Yes, turn on your cameras and turn on your microphones and talk. We all have, well, I don't know, a minute or two, maybe.
Okay, I'll go first and go quickly then.
Thank you, Mike.
I thought I'd echo the presiding judge's comments. I thought everyone did excellent. A few compliments and a few critiques on things that you guys can work to improve on. I really enjoyed your guys's use of inflection in your voice when you were really trying to stress certain points. It really comes across well to a jury. I thought, kind of on the flip side of what the judge said, I actually thought the witnesses did a phenomenal job of always trying to add in and spin their side. And the judge was correct in how you can tailor that. But props to the witnesses to make sure that they're always trying to point out what they want to say. A couple things, I know it can kind of be uncomfortable, not something you're used to. There's a few kind of robotic things that a couple of the attorneys were doing in terms of their movements and their hand motions. Just try to feel relaxed. It's very difficult, but when you're sitting in front of a jury or standing in front of a jury, that's something that really comes across. They want you to come across as a normal person, and if you look a little robotic, it looks a little strange. The other thing I would say is when you're objecting, be very confident in your position. A couple of you qualified your objections with, I don't believe this question is appropriate, or I believe my position is valid for this reason. The judge knows that's your position. So you kind of like undercut yourself a little bit, and it just shows more competence if you say, Your Honor, this question is improper because it's hearsay. Your Honor, this question is wrong because of this. And if you're wrong, the judge will tell you you're wrong, but don't undercut yourself without needing to be. And then the last point that I had was there was one really good impeachment of the CEO when the CEO was saying she didn't remember that Carson had told her about the carcinogenic. The impeachment was great. You brought the statement up. There just needed to be one more question. You kind of like let a little left to be desired. You should have hit the CEO with one more. So you telling me right now that you don't remember this saying it, but in this statement, you testified, you previously said that she told you at the time of firing that this fertilizer had carcinogen. And then that has to be a yes or no. That last question was just missing, but overall, I thought it was great from everybody.
Right, thank you.
Sydney, did you hit submit for your score sheet?
Yes, I just sent Nicole a quick question by text. I was just gonna say, I really enjoyed it. I really loved the storytelling. I thought both sides did great on the objections that were raised, and it was fun. So thank you for the opportunity. Very, very well done.
Thank you.
Well, this is Chad. I can't get my camera is turned off by the host, but I do want to say both the teams, you did a good job. I especially like the closing arguments. I think that plaintiff's case did a very good job of tying their elements to the jury instructions. That's always very helpful for finders of fact. And as well, the defense closing arguments I thought was also very good, tying it back to really tricky questions about how to weigh that evidence. On the defense side, I also think that the cross-examination of Skylar Weir's plaintiff's witness, that was done very well because that's a very tricky thing. It's a very sympathetic witness. And I think you handled it well, showing the sympathy, not being too aggressive, while at the same time getting out all the points that you needed on cross. I think a lot of fact finders would appreciate that. Don't always need to beat up the witnesses as long as you get your side of the facts out. So I was very well impressed with how you all did that. You brought along everybody's attention. You know, I think that's something you need to do with fact finders, and you all did that very well.
Do we have any other scoring panelists?
Other panelists?
Chad's there. And then he wasn't.
Yeah.
There he is.
Yeah, I was the one just speaking. So now my face, but you heard my voice.
I would echo everybody's comments to make some specific call outs. Ms. Giselli, your opening statement was fantastic. You really got me on the hook there. I'm a defense attorney myself, and so I was over here like taking notes. I was like, that is fantastic. I want to use that. I loved how you argued comparative negligence. That's something that we utilize all the time. But really getting it into everybody's minds immediately right at the forefront. You laid it out really well without admitting that you guys had done anything wrong. And so I loved how you played that. That is certainly something, that's exactly how you'd want to do it in real life. And then Ms. Feeney, your closing statement was fantastic as well. So those two are two areas that just really stood out to me. But overall, just a round of applause for everyone. So certainly not something I would have been brave enough to do when I was in high school. So I'm just so impressed that you guys are out here doing this, and just really impressed by the quality of everybody's arguments.
Right, Melissa?
You all should take a round of applause right now for all of you. You did amazing, and it was wonderful, and it was a joy to watch. So I've done this for quite a few years, and you guys were amazing. So take a deep breath. Now that you're done.
Nobody died.
Nobody died. Everybody's good. You all did amazing, and we will get the next the scoring sheets in, and we will let you all know. But
Melissa, is everybody clicked submit so that we can dismiss, or no?
I
Be sure.
think, Sydney, did you click submit on your scoring sheet?
Nicole, I don't know if you saw my text. I had one quick question before I submit.
Okay.
Well, while she's doing that, I'll make one more statement to the youngsters. Let me help you figure out how to be as calm and as collected on your arguments as you possibly can, either opening or closing. Do it. Tell the story. You already know the story in your heart. Tell it to either your parents, a friend, an adult, somebody you're slightly scared of, until you can finally relax enough to just tell it with being genuine. Because I'll tell you, a jury is going to look at you and they're going to say, is this person real, or is this person just trying to woof me? If you're trying to woof them, they'll read that right away and they won't listen. But if you're being real, if you really believe it in your heart, then you'll be able to you'll show that by being relaxed and confident. Just a little trick, and the way to get there is to work it with people that you respect greatly.
All of you did great. I would just like to say to Stanley, when you're in front of the witness, make sure you're in front of the camera, the witness camera. Oh, I think we're good.
Oh, yay.
Yeah, they got all of our stuff. So you all are dismissed.
It's been an honor. Thank you, guys.
Thank you.
Good job, everyone.
Yeah.